Yes, I'd like to mention for listing of a matter from motion.
Please give it to the court master. There is for listing.
Yeah, please, sir. Victim is item number 2, madam.
2.
Yes, madam.
Yes.
We have submitted a leaf note also, madam. The conducting counsel, Mr. H. is out of station, madam.
Okay. Just wait for some time because
Fine.
we find that there is a
Report was
report.
yes,
So
madam.
we'll just examine the report first and
Fine.
then wait for some time.
Madam. May please, I beg to mention item number 5, Lordship. My password for the day, Lordship.
Okay. After a week.
Lordship, I beg to mention item number 6 of today's list, Lordship. My senior has some personal difficulty today. I prefer an adjournment, Lordship, for the day.
Okay.
Obliged, Lordship.
Daily list item 1 for admission.
May I please, Lordship? Lordship, in terms of the order dated 6/4/2028, my lord, petitioner was appeared before the Superintendent of Police Border, my lord. And on being appeared, my lord, she was allowed to go on bail. She was appeared, my lord, on 12/4/2018.
Yes.
This is the communication from the SP Border, my lord, Moira.
Sorry, we take your word for it.
Well, now she is on bail, my lord. My lord, appealing the order.
What are the documents by which you are linked with your projected parents and grandparents?
My lord, there is no such direct link document, my lord, except the statement of my elder brother, Paresh Chakraborty, my lord, who stood as DW number 2.
Pradeep,
DW2, my lord,
what's
my
the name?
Paresh Chakraborty, my lord. I have annexed this statement, my lord.
Okay. Mr. Sharma, we admitted for hearing. There's a document, at least exhibit 7.
Yes,
To that effect.
Heard learned counsels for the parties. Pursuant to the order dated 6/4/2018. The tribunal records have been requisitioned. They are available before the court. Stop. The petitioner is also on bail in terms of the order dated 6/4/2018. Therefore, the matter will require some hearing. Admit this for hearing in the month of September.
Item 2 for hearing.
May please, your lordship. Talking on last talk is on one direction.
Just a moment. Find Mr. Banerjee here. Thank you. Good to see you after such a long time.
Yes, pleasure. Lordship, on
Yes.
last talk is on one direction is given
Yes.
regarding to produce the present status police report of Mosolpur PS case number and Bisni PS case number also. I have received the instruction also.
She will follow prediction for town committee.
If this be so, then nothing remains the
Yes,
matter.
Lordship.
Lordship may
Matter may
fix
be
another
disposed.
short date, my lord.
Huh?
Lordship may fix another short date, my lord.
No, they have
Mr.
given an FR.
Yes, my
Yes.
lord, that's true, but.
Already
it-
the
you
informant had
accepted, my lord, yes.
accepted, already the informant has
FR is accepted.
accepted. And his statement is recorded before the learned CGM. Lordship.
Okay.
Lordship may fix on 7th, my lord.
Huh?
August, 7th of August, my lord, short date. Can dispose of the matter, my lord.
Okay. All sides are represented. Mr. H.K. Hazarika, learned government advocate, has produced a communication from the Superintendent of Police, Baksam Mushalpur, indicating that the I think that FR has been accepted by the informant in connection with the case referred therein. Next. The learned counsel representing the just add there, they said report is retained in record. They said that communication retained. Yes, the learned counsel representing the petitioner submits that the counsel on record is not available and therefore prays for adjournment. Prayer is allowed. List on 7/8/2024.
God bless.
Item 3 with 4 for hearing.
Fact, there are two appeals panel, the same judgment, two appeals
Please,
have
your
been
lordship.
preferred.
First appeal, my lord, is my appeal.
Yes, first appeal is by them. I'm just indicating,
Yes.
first appeal is by them, is a part of the order. And we are also agreed by a part of the order, so we will file appeal. Our appeal is second. So let them start.
Tell my lord, my lord, what the issue is. My lord, we proposed, my lord, the appellants in this appeal, we proposed, my lord, a scheme of, my lord, merger. My lord, the appellant number 1, which, my lord, is a tea estate. Or, my lord, the Govind tea estate, it has one tea estate. It doesn't, my lord, have a factory. It's a large, my lord, tea garden. The appellant number 2 here, was one of the petitioner number 2. They have, my lord, 7 tea gardens. So there was a merger.
Is it not a coincidence? Yesterday, there was an obituary in the advertisement in the newspapers, and today we are on board with this matter.
Yes, my lord. My lord, in fact, my lord, we traveled yesterday, my lord, that's, my lord, what we were discussing as well. That, my lord, it's a coincidence, my lord, that we were here. Absolutely, my lord.
Okay, that's besides the point.
Yes, my lord. Well, it's always a pleasure, my lord, to be before my lord's here. But, so, my lord, that's what, my lord, here's, my lord, that will be important, my lord, because what has happened, my lord, this one tea garden, my lord, company, my lord, wants to merge, my lord, into, my lord, this 7 tea garden company. My lord, the shares and quite naturally, my lord, the promoters of both these companies, my lord, are, my lord, the same. Now, there is a dispute. My lord, the learned judge, my lord, has held that yes, I'm okay with the merger. There's no difficulty. There are enough economic reasons for the merger, but I'm unhappy with the share exchange ratio. That's what the learned judge has said. That's what we are agreed by. That's why we have come up. And my learned friend says that there should be no merger. Now this happens, and the person opposing it is a family member of the promoter who's now passed away. Shormila Shetty, who claims, and there are litigation, otherwise, apart from the company proceedings, where there's a dispute with regard to the shares. Because what had happened, I'll tell my lord also briefly because it will be necessary, because I'm sure my learned friend will go into that, my lord. The respondent who's opposing it, my lord, has some shares of her own, about 3%. She, my lord, also claims that shares have been transferred about 7% from her mother. That is under challenge in a suit before
Just a moment, you see, this was a shareholder's, what you call opinion,
unanimously approved.
yes. But then, what is the genesis of the dispute then?
Well, the genesis of the dispute is, my learned friend's client comes and says that because shares are getting issued in the appellant number 1, the shareholders of appellant number 1, by that, the shareholding of the promoters are getting increased. That's one of their grievance. But my submission is that is only a consequence, because obviously, if a company is merging, then the shareholders of that company will get shares in the parent company. So that is only an incidence of the merger. So you can't take away the economic rationale by saying that as a incidence, the original promoter shareholding is getting increased. That can't be a reason to oppose a scheme. And I'll show Mafatlal exactly similar issues a reason where there were disputes between the family members, and the court said, sorry, this shareholding dispute is not something which we're going to look at into a scheme of arrangement or a scheme of merger. So this is really the issue. But I'll try and explain the shareholding structure so that one knows.
Mafatlal means you are, that, what, I name I forgot. Mihir.
Correct. Absolutely. 97 Supreme Court will recall Mihir Mafatlal. They were also in a similar situation where disputes were going on.
I won't remember entirely after such a long period. But
I'm sure as soon as I show the judgment, will recall everything with regard to the matter. Because knows the scheme now also the scheme, and that is also another issue, because now schemes have all gone to the National Company Law Tribunal. So this is one of the remnants of the matter which, because it's a High Court order we had before, my lord. Otherwise we'll have to we had to go somewhere else.
What was the finding of the single judge?
The learned single judge said that yes, I'm all right with the economic rationale of the scheme, but I'm not happy with the share exchange ratio. Therefore, directed the registrar of companies Shillong to have another valuation done.
You are agreed by that?
I'm agreed by that. I'm saying if the shareholders are chosen, then just because a disgruntled shareholder comes, and very important, she had noticed she did not come to participate. And I'll show one of the cases which says if you have not participated, which means you really have no opinion or you have not really opposed the scheme.
But there's a query. Let us say in the process of merger, the share valuation is made, say 10 rupees. Now, if somebody can demonstrate that the taking into account of the parameters, relevant parameters, the share valuation ought not to have been 10 rupees, it ought to have been 10,000 rupees, let us say. Then why, even if he or she does not participate, cannot have a right to voice the grievance of the lower valuation? Because you see, I'm thinking it aloud on the rationale of a sales certificate
Yes.
issued in respect of a property. So even after the sales certificate is issued, it can still be questioned on the ground that the value obtained was grossly inadequate and could not have been sold at that price.
Well, I'm not absolutely bound on the. I'm not on the absolute proposition that she cannot challenge. I'm only saying this as an incident that whether she should really be heard so much to say because she has not participated. I'm not giving it as an absolute proposition, saying no, under no circumstances can she not challenge because she did not participate. Because what has happened is there are 3 chunks of shares. As I was explaining, she has her own share, 3%, claims from her mother, 7%.
You start from the beginning because we are just asking questions from out of the way. Is present
Very well,
in the
yes, the first.
Both of us has to follow.
There's the scheme of merger, as I said, a proposed scheme of merger by which this Buragoin tea company merges with B&A Limited.
Is any synopsis of your submissions are on record?
We have a list of dates which might help at least to get the dates. And the synopsis we have not made any synopsis, but it also appears.
Because there's a difficulty.
My lord.
We are not sure about the constitution of the roster from next week onwards. We don't know.
Oh.
Here we don't have a fixed roster. So it depends on the wisdom of the Honorable Chief Justice, who is the, prepares the roster. So because if we hear in part,
My lord.
and if you don't have your written synopsis to refresh our memory, tomorrow may be
My
another
lord, we
day.
can prepare, my lord, a synopsis, my lord, by, my lord, after, my lord, the conclusion of hearing, my lord, and hand it over, my lord, if that's, my
Yes.
lord, a possible, my lord, solution.
Okay. Okay, both sides will have to give us.
Yes, yes,
because
yes, of course.
Next time when we can continue, we don't know. Because there's again a full bench where we have to break in the second half.
I see, my lord.
So that's why we may not be able to, if it's a voluminous, we may not be able to continue it today. So therefore, just we are putting it to your notice.
Very well, my lord.
This is how we have placed today.
My lord, I'm, but like I said, my lord, it's a privilege, my lord, and a pleasure, my lord, to argue before my lord. So, my lord, I'm quite happy, my lord, that if whatever, my lord, progress we can make today, then, my lord, whenever, my lord, it's possible for my lords to, my lord, if, my lord, we don't finish today, my lord, both of us, then, my lord, can, my lord, this, my lord, we have prepared, my lord, a list of dates and some other stuff, my lord, and, thank you, my lord.
Because in the balance of scale, when we don't see you, the balance of scale says the weight here and weight there. We don't expect this to be over by today.
Lordship's indications are quite clear.
Huh?
Lordship's indications are quite clear. Anyway.
So my lord is saying that we will not finish because.
No, I'm just calculating the weight.
Both sides.
Old habits die hard.
My lord, I'm not, my lord, able to, my lord, argue for long. That, my lord, I'm sure, my lord, I'll try and.
Yes,
If, my lord,
it's
looks
okay.
at,
At least we have something to go by. Yes.
my lord, in the list of dates, if, my lord, turns over that first page, then, my lord, will find, my lord, incorporation of the two companies. Then, my lord, May 25, 2012, my lord, at page 2, my lord, will find board resolution passed in the board meetings of the transfer company and the transferee company approving the draft scheme of amalgamation and also the valuation report indicating the exchange ratio of shares which were duly approved by the respective boards of directors of both the companies to replace both and company just go ahead. Then, my lord, September 7, 2012, my lord, is the will of, my lord, Mr. Bodua. And, my lord, this I'm just, my lord, as a matter of reference, I'm saying this because, my lord, here, in fact, the daughter, my lord, has been, my lord, disinherited because there's a serious dispute with regard to, my lord, certain shares which were, my lord, transferred, and that will come up. That's why, my lord, I'm giving the background. My lord, what happened, my lord, Mr. Borua, my lord, had about 27%, my lord, shares in this company. So he had, my lord, transferred, it was in his name, and he had purchased it. So he had transferred it in joint names. And then, my lord, when he wanted to, my lord, transfer it back to a family trust, my lord, the daughter refused to sign. And that's why, my lord, another suit was filed with regard to, my lord, a challenge saying that you have to transfer. It's not your shares. So the declaration with regard to that the shares are only Mr. Borua's, and, my lord, during his lifetime only, my lord, he filed that suit. That is, my lord, being contested, my lord, elsewhere, my lord, in Jorhat. So because that becomes important because my learned friend's client, my lord, comes and says, I'm 38% shareholder, which is not correct. Because this 27%, which was held in joint name and which was exclusively shares of Mr. Borua, my lord, that was, my lord, transferred, and there's a suit pending, there's an order of injunction with regard to that. The 7%, which he claims,
Why not before the company law board?
my lord, at that time, my lord, because it was a declaration, perhaps, my lord, they did not think, my lord, section 111, all, my lord, section 58 now, my lord, because it's a question of, my lord, declaration that, my lord, the shoot, so the shares are only held, my lord, by Mr. Borua, and she has no right. Because, my lord, knows in India, my lord, we don't have, my lord, a doctrine of advancement, which means, my lord, if the shares are owned by the gentleman or, my lord, anyone, just because, my lord, it is transferred in the name of someone doesn't mean, my lord, she becomes the owner. That's, my lord, the law, my lord, so far as we are concerned. Even if she is the daughter. So anyway, that's, my lord, the principle on which, my lord, we rely, my lord, have those shares. So when she says, my lord, that she is 38%, it's not correct. 27% dispute, and even the mother's share, my lord, there's a dispute because, my lord, the mother never signed, my lord, the share transfer certificates or, my lord, rather the dematerialized, my lord, forms with regard to transfer. So she's actually malad at
Because
3%.
Unless there is a buyback agreement or the taking back agreement, transfer made is an absolute transfer. It can't be conditional transfer.
That's what.
No, malad that the challenge is malad that mother never signed.
It was in joint name.
And the joint name malad is the declaration that obviously you did not hold it. It's in joint name.
Okay. Okay.
Joint name saying that you have no title to the shares.
What is the status of the suit?
Malad the suit is malad what has happened malad there's a will malad has seen malad the will I mentioned. Malad that will probate is pending malad before the Calcutta High Court. Because malad property is there. Now malad all other heirs have given consent. Malad she is not given consent. Quite naturally malad because the will malad disowns, it disowns malad everything. So malad she is not given, so it is pending.
Suit in Jordan.
Suit malad is kept in abeyance because malad the probate has not been granted. It is awaiting malad the probate in the will for malad the executor to be substituted malad in the suit,
Which is pending in Calcutta.
which is pending malad the probate application is pending in Calcutta.
In my rudimentary language, what you call village colloquial, it's a simple jalebi litigation.
Simple,
Absolutely,
which is correct.
absolutely.
Which is correct. Unfortunately, malad that's malad unfortunate malad, but it was instituted by the father himself. So malad we malad
Jalebi, my lord, more so because it's a dispute basically between father and daughters. And there is an introduction of a third person, which I'll show my lord.
So malad just malad to come back to the list of dates malad September 17, 2012 malad that's the entry at page 2. That's malad the will. Then malad October 1, 2012 malad very important because malad B&A Limited malad is a listed company.
October?
1, 2012 malad at page 3.
Yes.
Malad, in principle, approval, no objection issued by the Bombay Stock Exchange under clause 24F of the listing agreement to the proposed scheme of amalgamation issued to the transferee company, which is a listed company. Because I am showing malad only the parameters so far as the scheme is concerned. We are not concerned malad, we can't be concerned malad with the dispute malad with the shareholder. That's a secondary issue. If the economics work out, then malad, why should there malad be a resistance? Malad to malad really malad listen to malad a disgruntled shareholder malad to stop malad the scheme. That is malad my submission would be. Then February 11, 2013, order passed by the learned company judge in company application 2 filed by the appellants directing separate meetings of the equity shareholders, the transfer company and the transferee company to be convened and held on March 23, 2013 for the purpose of approving the proposed scheme of amalgamation. Then February 26, notices were served individually by post upon all the equity shareholders of the transferor and transferee company together with the copy of the scheme of amalgamation statement required. Then February 12, notice of the meetings of the equity shareholder transferor were advertised separately in the Assam Tribune and English and Doinik Janmabhoomi in Assamese. That's one of February 27. Then March 23, 2013, meetings of equity shareholders of the transfer and transferee company were duly convened in terms of the order date February 13, 2013, presence of the learned chairpersons, advocates of this honorable court who were appointed by the order passed by the learned company judge, para 8, page 64, 62, volume 1, stay application. Separate meetings were held for equity shareholder transferor and transferee company respectively. 5 equity shareholders of the transfer company were present, person proxy through authorized representative in meeting of the equity shareholder transfer company, whereas 19 equity shareholders of the transferee company were present in person proxy as authorized representative in meeting of the equity shareholders of transferee company. Resolutions were passed by all the shareholders unanimously. There's no dispute that the objector, in spite of notice, did not attend the shareholders meeting. 9AB, page 62, 60, volume 1. Hemendra Prasad Barua, since deceased father of the objector, responded to, attended the equity shareholders meeting of the transferee company and had voted in favor of the scheme in respect of his entire shareholding in his individual name being 8618 shares, 27.8% transferee. Now, very important because of the dispute now, the daughter can't claim that I can change or I will oppose what was voted for. So that's exactly what the stand is now. She says I am 38%.
Is it a ground that she was not properly notified prior to
Yes,
the?
we have
They say we did not receive notice. That's one of the stand which they no proper notice has been served the deponent, who's one of the shareholder of the company, stated on that, that's one of their stand here. But well, it's advertised, company is here. That's how meetings happen. According to us, notices were sent. And in any event, Malad, her entitlement is 3% on her own. This 27%, which now she claims is voted upon. Because the father has voted for that.
What is this shareholding pattern? Can
Well-
we have a document, any document here to show the shareholding pattern?
Well,
As you claim and as they.
I'll tell Malad. Malad, 3%, Malad can, these are approximate figures, Malad, which are accurate. 3% is Malad her own shareholding.
What is the name of the daughter?
Malad Shormila Shetty. This one number 2, Malad, in the proceedings.
Person shareholding of which company?
Or Malad, the transferee company. Correct. B&L. Because transferor company is held by another company, Malad, which Malad is again Malad owned by Malad the promoters of B&A itself. Without this dispute, Malad, it's really Malad what we say, Malad, it's a vanilla merger in that sense. Question is whether Malad this dispute at all Malad will be looked at or not. So 3% Malad of her own, 7% and odd Malad comes from the mother, which is Malad under challenge. Which Malad she says the mother has transferred to her, but Malad there is discrepancy Malad with regard to Malad the transfer document itself. And Malad 27.8 is Malad a major chunk of shares which was voted upon by the father.
That was in the joint name.
It was in a Malad purchased by the father, held in the name of the father, then Malad transferred to both their names. In fact, Malad wants to it.
27 point?
Malad 27.8.
May I ask you, although these principles have been settled, but is once you say that the shares were purchased by the father and then held in the name of others, does in any manner this Benami transaction applies here? No.
No.
So it isn't the family members are the beneficial owners then.
Yes. It will go according to Malad. It is really Malad. It belongs to the estate of the father. So that's why I said Malad, the law is
This is joint holding between father and the daughter.
yes. Well, so far as the 27.8 is concerned, very important. Because one of the father, quite naturally, one of the first named holder in law, one knows he is the one who exercises voting rights. And those shares were voted upon by the father. So the shares can't be in the reckoning anymore. The dispute is irrelevant so far as the company proceedings are concerned. The daughter cannot make it an issue so far as 27.8 is concerned, because it was already voted upon by the father, who at that point, and it cannot be in dispute, legitimately was entitled to exercise his right in respect of the shares. So this is, I think, Mullah, with the greatest respect, Mullah, that this issue is not to be looked into at all. That's my, Mullah, submission, because it's been voted upon. So now you can't claim post facto the meeting to say, oh, now I'm entitled to this, therefore I shall now oppose. I understand your opposition with regard to the 3% which you have, and at the highest, 10%, at the highest.
What happens to this 27.8 going by your argument?
Well, that is the subject matter, Mullah, of a suit TS 41 of Mullah 2013, which was filed by the father during his lifetime. It has to Mullah continue. But that is Mullah post scheme and post his death. So the 27.8 Mullah is not in the reckoning at all. Malad, the 27.8 malad just malad also malad dispel malad any malad issues with regard to that. In terms of the will malad, it goes to a family trust. And malad, even if you add someone's name in an account, it is right. Still, malad, one has to prove that the intention was malad to transfer the shares to her jointly. Otherwise, malad, it's like a nominee. Malad knows malad, and sometimes malad, at least malad, before malad we came into law, we thought nominee means that you really own it, but that's not correct, because nominee only means malad that you hold on to it after the death and it goes in the way the testator or malad the person's malad estate malad devolves.
The nominee, as we understand, is that to whom the shares will devolve after the.
No, malad, the law is malad, it belongs to the estate. No, malad, it doesn't. It can only malad now malad there was a Bombay High Court judgment malad will recall saying malad that in a share it is to devolve, but then malad the Supreme Court reversed it, and malad now malad nominee only means that you hold on to the shares really for the benefit of the estate. So malad the person who owns the shares, it will devolve according to malad his estate malad wherever it goes.
What is the date when the voting took place?
Malad, the meeting malad date is on March 23, 2013. That malad will find at page 4 of the list of dates.
March 23.
Yes, ma'am. Page 4 of the list of dates. Malad.
Just to understand things,
Yes, ma'am.
what is the date of the will?
Malad, the will is September 2012. 17 September 2012. That's at page 2. It is also malad part of the proceedings, malad, page 1496 to 1522. Malad, I'm only giving this background to really show that malad in the framework of malad a merger, it is not relevant. Because we are really concerned with shareholders' approval. And malad, if there are economic reasons as to why malad the scheme should happen, malad it should happen. As a consequential side issue, if malad the shares of malad the one of the promoters or malad the promoter group of the company increases, that is really a incidental side issue which cannot be the consideration. Because that seems to be malad their case. And malad the learned single judge, I'll show malad went into malad the question saying malad because the share exchange ratio malad was 586 shares of rupees 10 each for one share of malad 1000 rupees. a maths was done by Mullah, the learned, with the greatest respect, Mullah, by the learned single judge, Mullah, and said that no, you therefore have it revalued. But I'll also show Mullah judgments, and Mullah are aware that Mullah generally Mullah share exchange ratios and Mullah the share valuation are left to experts. And if they have said that this is how the share should be valued and share should be really issued, that is Mullah what really Mullah should be accepted, because the law Mullah, as I understand, and I'll show Mullah from the Supreme Court judgment as well, the court is really to act as an umpire. That's one of the famous line Mullah in the Supreme Court judgment. When it comes to a scheme of merger, demerger, the court is really to act as an umpire to see that all the really check boxes Mullah or tick boxes Mullah are filled, and that's it. Because it is considered to be commercial wisdom Mullah of the shareholders.
Just a flip side, because
Yes.
I always think here and there, I get, I get distracted. We all thought at one point of time that what is the diabetes level? Then came this litigations, class action suits.
Yes.
Now we have come to learn that the glucose level is something else to be a diabetes. So perhaps whatever is done, litigation perhaps may show some way of whether the evaluation is right or wrong. That standard calculation of the diabetes level has now changed.
Yes.
High pressure blood level also is now changed.
Now changed. Yes.
So it is all happened because of class litigations against the drug companies.
Mullah,
Just a flip side, nothing to do with this case.
no, I know, Mullah, but diabetes
somehow I
Mullah
get
was
distracted.
considered to be Mullah one of the major scams Mullah, which Mullah the US drug companies really pulled Mullah on.
No, I get distracted. I'm
All of
just
us.
saying this.
No, Mullah is correct. Mullah parameters change. Like Mullah, the law keeps changing as well. It's not that Mullah law doesn't change as well.
Because if 10 rupees, 587 shares would be 5,000 rupees.
Five.
If it is calculated at 1,000 rupees, perhaps that is a possible view that the valuation is had to be made because there's a colossal loss of 4,000 rupees per share.
Mullah, that's Mullah won't be the point, because Mullah the tea garden Mullah, if the shareholders think Mullah the tea garden is more valuable, because Mullah it is a quite a famous Mullah and well-known Mullah tea garden Mullah which is getting merged. And it stays with the shareholders. It's not going out. The value, Mullah, that is very important. Even if Mullah there's a difficulty Mullah with regard to the share valuation, but the value Mullah stays with the shareholders themselves. I own two companies. One company, there's one tea estate. I merged this tea estate with my 7 other tea estates. Shares which are issued to this company also stays with me. Because the daughter is in dispute, or daughter as a minority shareholder is in dispute, can't mean Mullah the scheme will get stuck. That is what I'm on. Can you Mullah appreciate today? It's not that Mullah anyone is losing. Majority shareholders have thought, including Mullah public shareholding, that this is how it should be worked out. This is a listed company. Why should Mullah, and Mullah, I put my argument in a question form, why should a father-daughter dispute become a really Mullah, to say a platform to resist otherwise economically viable and economically reasoned scheme? That is Mullah, what Mullah, we are joining issue Mullah by saying Mullah, this should not have come in at all. And the central government regional director also Mullah, gives an affidavit saying it's oppressive to the minority shareholder. I'm sorry, who's he to say it's oppressive to the minority shareholder? It's not an oppression, a mismanagement petition. In fact, Mullah, I'll also Mullah, show that.
Minority shareholders of which company?
Mullah, he says a BND.
PN.
Yes.
Transfer income.
And Mullah, I'll show.
There
See,
is no objection from the transferor company.
no. Mullah, I'll also show Mullah CP 186 of Mullah 2013. The daughter had also filed a mismanagement oppression Mullah petition against Mullah this company BND Limited. And one of the issues she raised was this amalgamation. That Malad now stands dismissed.
Where is that order?
Malad, that is there. I'll show Malad, it's Malad there, Malad, in this, in fact. Malad, she did not, chose not to. First of all, Malad, the company was really, Malad, if I can use the expression, harassed for a long time. And finally, Malad, not pursued and Malad dismissed. That order is there, Malad. In fact, Malad will find that, Malad, in this bunch itself. Malad, page 15 to 22, Malad will find, Malad, immediately after the list of dates. July 2017. Page 15, just Malad, for the records, Malad, page 15 and page 22, Malad, all. It was dismissed, Malad, the main company petition was dismissed, Malad, on 13 July 2017.
Well.
Now, Malad, sorry, just Malad, to come back, Malad, to the list of dates and quickly, Malad, finish it. Malad, we were on, Malad, March 23, I've shown page 4. Then, Malad, page 6, Malad, will kindly come to of the list of dates. So, Malad, independent reports are filed, Malad, affidavits, Malad, up to March 25. Then, Malad, sees March 23 itself, Malad, the last entry on the page 6, second stage confirmation petition being CP 3 of 2013 filed by the appellant before the learned company judge for seeking sanction of the scheme of amalgamation.
In both the reports, there is no objection referred
No,
by the chairman.
no, Malad, unanimously, Malad, approved by both groups of shareholders of both companies. Then, Malad, April 9, order of admission of the company petition, which was filed by the appellant in the second stage for confirmation of the scheme of amalgamation, passed by the learned company. Directions were given for service upon the central government through the regional director, Eastern Region, Ministry of Corporate Affairs, Registry of Companies, Shillong, and directions were issued. Then, April 25, communication issued by the regional director after the receipt of the company petition, checking various documents. Then, May 8, everything, Malad, furnished to the regional director. Then, Malad, May 9, Malad, and is when she, Malad, comes in and opposes. Page 8, Malad, will find. May 9, 2013, Malad, opposition filed by, Malad, the objector Shomila Shetty. Then, Malad, June 14, 2013 is regional director's affidavit. Then, January 24, 2014 is interim
Just a
order.
moment.
This,
sorry.
this opposition was filed in which matter?
Malad, in this company,
In this
in this,
This
in-
one.
to oppose the scheme. And this is at the second stage. Malad knows first stage, Malad, company application when Malad meetings are directed. And then Malad company petition after Malad the results and Malad receive Malad from the chairman of Malad the meetings. Malad, you file a company petition for the purpose of final sanction. So the opposition, Malad, is in the final.
You'll have to also refer to the provisions because Companies Act is no longer,
Yes,
so. we have
because
lost
that's an
track.
issue Malad will also have to consider. Because Malad, I found Malad now Malad knows all these scheme matters Malad are now before Malad the National Company Law Tribunal. But Malad, there is no provision. And Malad, the transfer provisions, Malad, of section 434, Malad, of the Companies Act 2013. Malad, there is no provision, Malad, for transfer of an appeal to the.
No, it's been decided judicially. There was a judgment of the Supreme Court where it says that the company appeal from a single judge will remain in the High Court. I think that is already settled.
Malad, I was a little. Malad, we'll just check on that. Malad, we'll just check on that.
Yes, yes.
Because High Court order, Malad, can't go, Malad, there. That's Malad the. It, Malad, has to be, Malad, the jurisdiction, Malad, in terms of, Malad, even the General Clauses Act, my lord, section 6, my lord, subsection E, it gets retained, my lord, by the court, my lord, so far as the appeal is concerned.
I remember reading it.
My lord, we'll just check on that.
Ah.
Immediately, my lord, I can't, my lord, recall, but just check on that. Because that, my lord, should be, my lord, my lord, I'm sorry, I haven't, my lord,
No, it's okay.
looked at the
because I
judgment, but my lord, that should be, my lord, the law, my lord, according to us also. Because, my lord, it's an appeal.
Possibly in that case, it has been said the matters pending before 2016 will remain.
No, there's a reason for that.
Right.
Because the notes available here
Right.
indicates that on the last occasion,
Right.
when the matter was argued, question of mental ability was taken up.
Yes.
But thereafter,
This
we don't see anything refer to that. So it is in that context,
Possible.
we had I remember having read that the appeals before the High Court would remain if
I
it's
just tried to-
against the single.
I'll just try to find out.
Uh-huh.
about that.
But I may be wrong.
No, my lord,
uh,
that, my lord, is also, my lord, we'll, my lord, try, my lord. So coming back, my lord, to
Because reading was just a cursory reading, we did not read it in context of this matter.
My
So
lord.
therefore, I won't exactly recollect. but
My lord,
this is
we'll
what
also, my
the-
lord, if we can lay our hands, my lord, on that judgment, then, my lord, it will really, my lord, conclusively, my lord. Because otherwise, my lord, fourth, like I said, my lord, my submission is, my lord, 434 doesn't contemplate, my lord, transfer of, my lord, an appeal. It's from a order of the High Court, so, my lord, the division bench, my lord, which is, my lord, really has to, my lord, determine, my lord, the question, my lord, sanctity of, my lord, that order, my lord, whether it's correct or not. Now, my lord, in the list of dates, page 8, January 24, 2014 is one of the order in the then pending company petition. Then, my lord, page 9, my lord, are only, my lord, procedural, my lord, things, my lord, which happened. And, my lord, she had tried to, my lord, stall the company proceedings. Then, my lord, can you see page 10 at the top, my lord, the entry will find, my lord, March 3, 2015. Order passed by the learned company judge rejecting the prayer of the objector Shormila Shetty to keep in abeyance the second stage confirmation petition before the learned company judge, being CP number 2 of 2013, pending the disposal of the section 397-398 company petition, which was filed by the objector before the then company law board Kolkata bench, being CP number 186 of 2013. Then, my lord, April 6, 2015, my lord, is the appeal got dismissed. Their appeal got dismissed. Then, my lord, July 18, 2015 is, my lord, what, my lord, we are concerned with. That's one of the impugned order. Now, my lord, we are joining issue by, my lord, saying, my lord, the litigation history, my lord, is not relevant and should not have been looked at, my lord, by the learned single judge for the purpose of, my lord, not permitting, my lord, the approval of the scheme. And I'll show, my lord, the findings are, my lord, otherwise economically found, my lord, yes, this is the correct thing to do. Lord, can you see, my lord, the narration which we have given? I'm just reading, my lord, the narration of July 18. Order impugned passed by the learned company judge, second stage confirmation petition, recording no objection to sanction of the scheme of amalgamation, but keeping in view the litigation history in the transferee company and the objections of the objector as well as the objection of region director, that the learned company judge directed that the objections.
Yes, you got the observations. Action is path.
Action ispat, my lord, is on the question, my lord, of a winding up petition, my lord.
Yes, but the observation here is transfer of a winding up petition to NCLT is only where pending proceedings have reached a stage where it would be irreversible, making it possible to set the clock back. That company court must proceed with the winding up instead of transferring the proceedings to NCLT. So this is the observation which can be read that if about the
Irreversible
suggestion-
situation, yes, my lord.
I don't.
We did not
just read
think,
that.
my lord, from that side. Yes, my lord, this is in respect, my lord, knows there are 3 judgments. Action is path.
No,
We have the
I-
action is what we have.
I have not read and analyzed it. It's only a passing remark. I somehow remember.
Yes, yes, Malad, absolutely correct, Malad. We have Action Ispat, Caledonian Jute, and Malad. Shrey. Naveen Chandra.
So
Three of them, Malad, which, because in 4.3, Malad will recall, Malad, initially, Malad, it said, Malad, that the transfer provision said that winding up petitions for which notice has not been served will all Malad go automatically get transferred. And then Malad, they said it will get transferred from the date when the central government notifies. Then Malad, there is a company's transfer of proceeding rule. Then Malad, again it was amended to say the winding up petition, and that is what Malad looked at, saying Malad, where there's no, if there's no irreversible situation, then it should be transferred.
It's okay.
So here, Malad, there's no provision for transfer on appeal. If a scheme was pending, yes, but we are in appeal. Then Malad, just Malad, page 11. Page 11. Because Malad, page 11. Malad, in the middle of the page, no case was made out for any further determination of exchange ratio. Dispute with regard to ownership of shares are not relevant for annulling a decision of the shareholders in their commercial wisdom with regard to a scheme of amalgamation. Company gains a tea garden by the amalgamation. Then Malad, September 7, 2015, that is Malad, the appeals are filed. Then Malad, kindly come to page 12. July 13, 2017. That's Malad, the order I showed. Section 397, 398 petition filed by Shomila Shetty, objector before the then CLB Kolkata bench was thereafter transferred to NCLT Guwahati bench and was dismissed on merits in presence of the petitioner therein Shomila Shetty. All interim orders also stood vacated. The disputes raised in respect of the company therefore came to rest. So one of these RD is finding one of saying it's oppressive or not. I don't think one of the RD really has the jurisdiction to say that. And Malad, in any event, Malad, the main company petition, Malad, which the shareholder had filed, that got dismissed. I can't be, Malad, vexed over and over again. We, the majority shareholders, have taken a decision to, Malad, merge one company with the other. At the share exchange ratio, which we have thought is reasonable and correct. Now, you, the minority shareholder, if you have a difficulty with your father, it can't be that will then prevent or will defeat the economic rationale behind the scheme. Then Malad sees September 21, 2020. Very interesting, Malad. Kindly see, after 3 years, again another petition filed of mismanagement and operation. Termed Malad as class action, September 21, 2020. This is also dismissed. Another company petition filed by Shomila Shetty, objector under Section 245 Companies Act, in respect of the affairs of the transferee company, appellate number 2, herein before the NCLT Guwahati bench, being CP 10 245 2020, which was then transferred to the principal bench.
Alleging mismanagement. No.
Yes, Malad, this Malad 245 Malad is really a class action, but in the same thing. Malad is absolutely correct. So same 2017 Malad, the original one got dismissed. 3 years down the line, again she filed. And then Malad, kindly see April 8, 2022, condonation of delay application filed by Shomila Shetty, objector from the order dated July 13 was dismissed by the NCLT Guwahati bench. She wanted Malad a recall of Malad after 5 years, recall of July 13, 2017 order. And that also Malad got dismissed. Then Malad, page 13. May 5, 2022, in view of the dismissal of the condonation of delay application by the order dated April 8, 2022, that the restoration application which was filed by Shomila Shetty for restoration of the sections 397 and 390 petition was consequently dismissed by the NCLT Guwahati bench. Then September 2022, appeal filed by the objector Shomila Shetty before the Honorable NCLAT New Delhi from the order dated April 8, 2022 passed by the NCLT Guwahati bench was dismissed as withdrawn, and therefore the order of dismissal of the company petition under 397 398 attained finality. Then next page, 14, very important, April 27, 2023. TP 36 filed by the objector was dismissed by the principal bench NCLT as there was no appearance in the petition in them. Second CP also dismissed. Kindly see this harassment unnecessary where it's only a company issue. Litigation the file one after the other. In respect of B&A Limited. And they're dismissed. And still we are opposed with regard to the scheme. All the orders we have also annexed the subsequent orders. Looks at the order of at page 24.
This, in this list of dates, the last order, election E, what is that proceedings about?
That was a class action for mismanagement oppression.
By the objector or an
No, by the objector. No one joined. By the objector. Absolutely, I'm grateful. By the objector. And no one joined her.
By any chance, do you have that petition for that class action proceedings, annexure E?
Yes, we will have that. We'll have that. We have annexed the first company petition is annexed. CP 186 that is annexed.
No, only for a different reason, because when you say class action and nobody has joined, I just wanted to have a look at that.
Yes, we'll have that. Have it printed on there. We just have that brought. We'll have that. But so far as the first company petition is concerned, kindly just take one page at volume 5 CP 186 1146 or 1151 volume 5 in the first appeal, item 3. One 1146 will find.
Is a consolidated index available for these paper books?
I think I'll just put in volume 1 it should be. I'll just. Yes, in volume 1 it is there.
Okay.
Volume 1 from page 2 will find the index.
That's okay.
No, page 2. Page 2. Index. 1146. We'll find this is her first company petition. Filed in 2013, immediately after the father's death. Let's see particulars of the company. This is in respect of B&A Limited, which is the transferee company here. And kindly take 1151. A meeting, subparagraph my lord 6.4. A meeting of the shareholders. A meeting of the shareholders of the company was allegedly held on February 6, 2012, wherein a purported scheme of amalgamation. My lord has that, my lord, this is Psyche, my lord has that, my lord, page 1.
Yes, yes.
For the said scheme was meant to substantially alter the shareholding pattern of the company herein and to dissolve and dilute the petitioner's stake in the company. The tea garden of Buragoin Tea Company Limited was lying closed and in operational since long. Amalgamation scheme as devised was not in the interest or benefit of the company. No notice of such meeting was served upon the petitioner. The Bombay Stock Exchange, wherein the shares of the company are listed, was intimated about the said meeting as late as on June 2, 2012. Subsequent meeting of the share will modify the earlier scheme and resolution passed in respect held on May 25. No notice or intimation such meeting was also served. Bombay Stock Exchange was informed about this meeting as late as on September 26. On the basis of the aforesaid shareholders meeting, illegal and vitiated due to non-service of notice upon the petitioner, consequent violation of mandatory British Companies Act 1956, company herein along with Buragon Tea Company Limited applied before the Honorable Guwahati High Court for sanction of the scheme in spite of a caveat being filed. So on such petitioner, no notice was served on the petitioner, subsequently moved the Honorable Guwahati High Court. Sanction of scheme is stated here that upon knowing the listing, the counsel of Mr. Shormila appeared, prayed for time to file a reply. Petition since an affidavit. Then kindly look at 6.5. The aforesaid scheme of amalgamation, a motivated act of operation to dilute the shareholding of the petitioner in the company and to reduce the petitioner to an insignificant minority from the status of single largest shareholder. The ulterior motive, the other ulterior malafide objection made in the scheme is to deprive the petitioner, deny her valuable rights in respect of 861,918 shares. This is one of the 27.8%. Shares to which the company, which the petitioner entitled exclusive father's demise. Respondents herein had earlier attempted to deprive the petitioner of the said shares, but having not succeeded, give shape to the altered design, the purported scheme of amalgamation was devised. All of this petition stands dismissed.
What were the prayers then?
Malad prayers, Malad will find at Malad page 1171. Declaration that the petitioner is sole and absolute owner of 861,918. Malad claiming right here with respect of the shares. Though Malad TS was already pending the title suit. Now, what effect, Malad, this will have also, Malad, on the suit, Malad, has to be considered later. Malad, I am not, Malad, getting into this. That's not the subject matter, Malad, of this.
This prayer C
Yes, Malad.
is the resolution regarding the amalgamation.
No, Malad, this is with regard to, Malad, amendment of the article. Because, Malad, the articles were also amended, which was challenging. Because, Malad, Malad, the first named holder of, Malad, joint shareholding, Malad, has all the rights, Malad, as Malad knows, Malad, in law as well. Thereafter, Malad, the articles were amended to also, Malad, have the executor, Malad, to have the rights. So that was what was being challenged. That also is gone now. And Malad, very important, she has never exercised rights in respect of the shares, ever. I don't know how, Malad, now she wants to, Malad, claim this as part of her rights or, Malad.
Prayer B, that any resolution includes the resolution for.
Yes, correct. I'm grateful, Malad, we did not, correct. Without, because she said no valid, no, correct, absolutely. Malad, prayer B, Malad, Mrs. Surana must have seen, Malad, that any meeting, Malad, she says, Malad, that's all. All that is gone now. So the question is, Malad, can she, Malad, pursue and, Malad, oppose the scheme at all? At all? When there's an economic rationale behind the scheme.
Ultimately, the learned single judge
Yes, Malad.
has held that the court has no objection to the scheme.
Yes, and that's very important. Malad, sees, Malad, I just want to show, Malad, since Malad has looked at the impugned order, Malad, kindly look at, Malad, internal page, Malad, if Malad is looking from the memorandum, it is page 41. Hopefully, Malad, it will match. And Malad, internal page 25. I don't know, Malad, the scheme as presented before the court, my lord, has that, my lord, paragraph, my lord?
Yes.
The scheme as presented before the court appears to be based on business commercial conditions of the two companies. The transferee company, which is already an established company having substantial goodwill in the market, seeks to consolidate its area of business by accretion of one more tea estate to its production base. The transferor company would also stand to benefit substantially by virtue of the amalgamation, as it will have sufficient safeguard by virtue of economies of scale and would stand benefited by an established management. Till this stage, the court sees no hindrance or impediment in the sanction of the scheme. In my most respectful submission, that's where, my lord, the court should have really stopped.
You are agreed by 2 and 3. Only
Yes,
amendment.
yes, yes. I'm agreed, my lord, by that portion. Absolutely, my lord.
There's a cross appeal also.
My lord, there's a cross appeal, my lord. They
Appeal. Not cross.
Independent
We have
appeal,
filed an
independent appeal.
Independent.
Independent appeal.
Against this judgment.
Yes, we are against the merger itself.
So you're agreed by only the direction at number 1.
Yes. Sanction of the merger scheme.
Yes, my lord, in the direction, my lord, it's absolutely, my lord. I, my lord, as court has no objection. Two, this is, my lord, where, my lord, we, my lord, join issue, my lord, with the greatest of respect, my lord, to the learned judge, my lord. However, having regard to the litigation history in the transferee company involving the objector and other related developments, and also having regard to the financial status of the transfer company is discussed, objection raised by the objector and the central government through the exchange ratio of shares cannot be brushed aside.
What was the objection of the central government?
Well, the central government, well, will find, well, the affidavit. I don't know how, well, they can get into this, well, at all. Well, at page, well, 318, volume 2. Volume 2. 317, well, it starts. And 318, well, at 323. Yes, at the bottom, well, we'll find. From the above submission appears that the scheme is against the interest of minority shareholders. I'm sorry, my lord, who's he? Sorry, my lord, Justice Surana will find that page 323, my lord, volume 2. At the bottom, my lord, will find.
I've seen that.
Exclusive benefit to the promoter group. Thereby, the scheme may be liable to be rejected, dismissed, prayed for before the honorable.
Was there any separate order passed sanctioning the scheme or not by the central government?
No, my lord, they, my lord, only have comments. My lord, they don't have, my lord, the power to sanction, my lord.
So
They can only, my lord, comment.
the objection is only by way of this.
Yes, yes. By way of an affidavit. That's one of the scheme of, my lord, things, my lord, if I may. It's, my lord, really the court, my lord, which considers, my lord, the sanction, my lord, knows, my lord. Regional government only, my lord, comes in, my lord, to say, my lord, what they. Now, I'm showing, my lord, the regional director, my lord, cannot get into a dispute, my lord, between shareholders and come and say, my lord, it's oppressive to the minority shareholder. No. Inquiry, my lord.
On this
Understand.
issue,
This, they have come to a finding. I mean, Is there objection that it is
No inquiry made. No inquiry.
against the interest?
Yes.
How have they arrived at
Ha-
this finding?
My lord, kindly, my lord, I don't know. In F, my lord, in the beginning, my lord, will find Rockland Realty, my lord, that holds, my lord, shares in the. My lord,
We have the habit of, going into areas where you're not called for. If you look into page, pointed out by elder brother, page 324. The statements, para number 3, how the information has come to be possession of the regional director.
Our information derived from the records of the case. Absolutely, my lord. And my lord, I'm grateful, my lord. In fact, F, my lord, he says, my lord, he only refers to, my lord, the Rockland Realty Private Limited, my lord, which is the owner, or rather, my lord, has, not owner, sorry, my lord, has, my lord, maximum shares in the transferor company. And looks into the balance sheet and all that, my lord, which, my lord, we have given.
That's how the records went.
So the interest of the minority shareholder means the interest of the minority shareholder in the transferring company,
Yes.
not in the transfer.
No.
I'm just.
And minority shareholder only means, my lord, the objector. There's no one else. And I'm grateful, my lord. Perhaps, my lord, we also did not think it that line. Minority shareholder, my lord, no one else has come. It's a listed company.
Even one could be enough
Yes.
for a company.
Yes, one could be enough, but, my lord, it's the daughter, my lord, who's having a constant fight, my lord, with the father. That has to be kept out of, my lord, in a scheme. Because, my lord, at 314, my lord, will find, my lord, the Bombay Stock Exchange, my lord, giving, my lord, the permission at 314. Sorry.
Just a minute.
Yes. Oh, please. But kindly come to Malad page. I was showing Malad page 314 since Malad has that same volume. Volume 2. This is Malad no objection Malad from the Bombay Stock Exchange. October 1, 2012. Yes, Malad, it's a listed company. So Malad, they have also Malad because no, it's a listed company. Malad, we also have to obtain Malad no objection Malad from the. Now Malad, if Malad wants to look at Malad the voting, 308 Malad is the report of the chairman. P08 Malad is the report of the chairman with regard to Malad, the transferee company. Paragraph 3 Malad will find. Said meeting was unanimously of the opinion that the said scheme should be approved and agreed to without any modification. Then Malad sees 309. Kindly see Malad the first name itself. And that's Malad, those are the shares. So voted on. Yes, yes, yes. Absolutely.
This also discloses page 308.
Yes, Malad.
You see the first paragraph. They have been summoned by notice served individually
Yes.
upon them by post. So service, the chairman acknowledges.
Yes. And published. She's chosen not to appear. And this report, Malad, we have to Malad, go by this report. It's the chairman's report to the court. It can't be Malad, disregarded Malad, just because Malad, a shareholder comes in, so I did not receive the notice.
That is always rebuttable.
But Malad, I don't know how Malad we will prove Malad if the positive Malad appears from Malad from this document. Then I don't know Malad how Malad the shareholder Malad really Malad will. She says I did not receive notice. I am showing Malad the report of the chairman.
No, this is something which we always come across in the litigations. For example, a decree being executed. At that time, somebody comes and says that notice in so and so is not served.
Yes.
So we again call those service reports.
The service report
And then-
affidavits and Malad to
Right.
show that Malad.
So it's a rebuttable
Yes.
presumption. So we really do it. So there is no difficulty if it can be demonstrated.
So Malad, my demonstration Malad is the report of the chairman.
When was the meeting held?
Malad, March 20, 23 Malad had given the.
Gap day of March 2013.
Yes, yes.
Here is his gap. So I'm saying gap day of March. Page
Oh,
310
sorry.
is gap day of
March 23.
March 20.
March 23, 2013.
We'll take a short break and come back.
Yes, Malad, voted upon. And then further down the list, find 11 and 12 are the trusts. In fact, the shares are also in terms of the will are to go to the family trust.
Which is 12.
Yes. My submission is that this raising this issue with regard to the 27% shares are really a non-issue because you can't change the way it's been legally voted upon. Post the gentleman's death, whether you are entitled to, not entitled to, that is the subject matter of suit. We think we have a good case. You might think we have a good case. Whatever it is, that will be decided. But the voting cannot be changed where the majority shareholders at that point of time in the meeting thought that this is a perfect scheme and this is also the share exchange ratio we will accept. And Mullah, kindly now, Mullah, take the impugned order once. Mullah, I find Mullah that there are judgments which are referred to, and in particular, I want to show Mullah one of the judgments, and then of course, Mullah, I'll show Mullah Mafatlal itself. If Mullah comes to Mullah internal page 22. Tiny similar in Hindustan Lever Employees Union, Mullah has that Mullah at the top of the page. The learned judge Mullah has quoted, or rather Mullah summarized the ratio of the judgments.
Yes.
In Hindustan Lever Employees Union Supra, the court examined the exchange ratio of shares of the two companies and posed the question as to what method should be adopted for arriving at a proper exchange ratio. Observing that there are three well-accepted methods to arrive at the fair value of the shares, namely the yield method, the asset value method, and the market value method. The apex court held that the usual rule is that shares of the going concern must be taken at quoted market value. In the said judgment, it was observed that the court will decline to sanction a scheme of merger if any tax fraud or any other illegality is involved. There was no such case here. In Mihir Mafatlal, the apex court held that the valuation of shares is a technical and complex problem which can be appropriately left to the consideration of experts in the field of accountancy. And Mafatlal Mullah, I'll show Mullah with some detail, Mullah. The next case, Mullah, very important. In Bengal Tea Industries Limited and Others versus Union of India, Company Appeal number 418 decided on 25th August 1987, a division bench of the Calcutta High Court held that in a scheme of amalgamation of two companies, it is not necessary in law to call for a meeting of the creditors and obtain their views on the scheme. Regarding objections raised, tiny c, regarding objections raised by the regional director, Government of India, that the exchange ratio of the shares between the transferor company and transferee company as provided in the scheme was unfair to the shareholders of the transferor company. The Calcutta High Court held that when no complaint was raised on behalf of the shareholders, regional director was not entitled to raise objection as to fairness or unfairness of a proposed exchange ratio of shares in an amalgamation of two companies, which is a matter concerning only the shareholders of the companies involved. Valuation is ultimately a matter of expert opinion. There are more than one method of valuation shares. Valuation would vary if different methods are adopted while observing shares and property shareholders.
Yes.
Now, Mullah, purpose of showing this, Mullah, this regional director is really no one to talk about oppressive Mullah to the minority shareholders. That's one of my first submission on Mullah this issue. Secondly, Mullah, I submit that today, Mullah, it's not as if Mullah the shares
Yes.
are going away anywhere. It still stays in the control of Mullah the majority shareholders or the promoter group Mullah of this company B&A Limited. Thirdly, Mullah, I submit that oppression to a minority shareholder, Mullah, the minority shareholder has to complain. And in this case, she has complained. And Mullah, that stands dismissed. So if I put my argument in a question form, then why should the court really go into that issue and say that it is oppressive to minority because the main action has been dismissed? At the time when that order was passed, of course, the company petition was still pending. And that's why I gave the list of dates to show that subsequently company petition stands dismissed. Recalling of the dismissal order after 5 years, that stands dismissed. Second company petition also stands dismissed. So how much credence or my lord, how much importance, my lord, this particular shareholder will be given, my lord, is really, my lord, a consideration, my lord, before this court also. Because my submission would be that she's had her try, she's filed company petitions against this company. Why should the economic rationale be stopped? And my lord, again go through, my lord, again Shillong registrar, my lord, will now determine the exchange ratio. And my lord, the shareholders, then my lord, what will happen is, my lord, what the majority shareholders approved, or what the shareholders, not even majority, what the shareholders approved unanimously, something else would be imposed upon them by court. Today, kindly appreciate, my lord, I as a shareholder, I say I am very, very happy with the share exchange ratio. Court says, no, you cannot be happy because one of your shareholders have complained. Therefore, I'm imposing another share exchange ratio on you. Because that's exactly, my lord, what will happen. And that's, my lord, where, my lord, we join issue by saying, my lord, really, my lord, whether, my lord, the greatest respect, my lord, to the court, my lord, that whether, my lord, court was really, my lord, should it have been moved at the instance of, my lord, this litigant to impose a share exchange ratio, which one of the shareholders have not approved.
Yes.
Lord, I want to show, my lord, now, my lord, kindly look at, my lord, what, my lord, because I think, my lord, it's quite an authority, my lord, the Mihir Mafatlal is, my lord, quite an authority on, my lord, this issue. Oh, just keep close. My lord, this is 1997. One Supreme Court cases 579. All in the report, I'm the Supreme Court as well. You must give what I have, no? I marked my paragraphs from there.
Citation to the SCC,
I'm sorry, Malad, I'm told Malad, the reference copy has been given as AIR.
Isn't it? The same judgment.
Same judgment, Malad, but paragraphs, Malad, unfortunately, Malad will differ. That's the, if I got Malad, this AI 97, Supreme Court 506. Malad, just try and Malad. अरे फिर देख लेना तुम्हारा काउंसिल की जजमेंट है कॉपी ताकि तो देख ले मतलब kindly come to paragraph 14 at Malad page 511. 9 objections were raised.
Yes.
9 objections were raised by the appellant. And Malad will see appellant Malad here is also Malad Mihir Mafatlal, Malad, one of the family members. Against the objector here. Against the proposed scheme of amalgamation, a shareholder of the transferee company. At this stage, we may not mention all these 9 objections. Ultimately, only 4 objections survive for our consideration, present proceedings, and to which we will make a detailed reference hereafter. Suffice it to say that at this stage, that after a prolonged hearing, Learned Single Judge Justice S.D. Shah overruled his objection by detailed and exhaustive judgment running over 240, covering various aspects of the matter, conversed before him, sanctioned the said scheme, moved on behalf of the responding transfer company. Division bench of the High Court, to which the appellant carried the appeal in appeal, confirmed the aforesaid decision of learned single judge by a well-considered judgment, which also ran into 136 pages. That is how the appellant original objector is before us in this appeal. In order to properly appreciate 16 grievance the appellant against the proposed scheme and his role as an objector, it will necessary to note the family history of the appellant, two of the directors of the respondent transferee company who have a common ancestor, Mafatlal Gagalbhai. The family tree is then, my lord, given. Then kindly come to, my lord, as the aforesaid family tree shows, appellant Mihir is the son of cousin brother of Arvind Navin Chandra, who is said to be at the helm of affairs of the transferee company, along with his son Rishikesh.
This is the judgment which said that court does not have expertise or
Yes,
something like
yes,
that.
yes. My lord, I want to show, my lord, then kindly, so my lord, Mihir, my lord, who was opposing is, my lord, a cousin, or my lord, the person, my lord, who was in control. Then, my lord, kindly come to paragraph 20, sorry, I'll just check whether it's 20. My lord, paragraph 22 at, my lord, page 513. As noted earlier, though a battle royal was fought between the contesting parties before the learned single judge, wherein 9 objections were raised for adjudication appellant. At this stage, disputes centered on the limited number of contentions which were canvassed for a consideration by learned senior counsel for appellant. Fourfold submissions for opposing the scheme were canvassed on behalf of the appellant as by Sri Shanti Bhushan, learned senior counsel. In the first place, he contended respondent company, while putting the scheme for approval of the equity shareholders meeting, did not disclose the interest of directors, namely Arvind Mafatlal and Rishikesh Mafatlal, belonging to the camp of Arvind Mafatlal, in the explanatory statement supporting the scheme, and consequently, the shareholders were misled and could not come to an informed decision regarding the approval scheme, with the result that the approval, kindly similar, by majority of equity shareholders to the said scheme has got vitiated. Then, 2, very important, the scheme as proposed was unfair to the minority shareholders. This is the opinion, submission made. Unfair to the minority shareholders represented by the appellant, and consequently it ought not to have been sanctioned by the court. The scheme was otherwise unfair to the equity shareholders, as the exchange ratio of equity shares of the transfer and transferee companies were expressly unreasonable and unfair to the shareholders of the transferee company MIL, insofar as it provides under the scheme that 2 equity shares of the transferee company will be allotted against 5 equity shares of the transferee company at the respective face value of ₹100 per share. That the appellant represented distinct class of equity shareholders as far as the respondent transfer is concerned, separate meeting. That is one of the argument which was made. Now, Mullah, kindly come to paragraph 24. 24, my lord, will kindly look at 24, the argument which was made, my lord, on behalf of the company. 29. On the other hand, paragraph 24, learned counsel, senior counsel Shri Surabji, appearing for the respondent transferee company, contended that there was no illegality, either procedural or substantive, vitiating the scheme, and there was no suppression of relevant material from the shareholders when the scheme was put to vote. That the personal disputes between the warring groups of the family, namely Arvind Mafatlal on one hand and the appellant on the other hand, which were subject matter of the pending litigation Bombay High Court, had nothing to do with the question of sanctioning the scheme for its better economic viability with which the shareholders were concerned, and that is the transfer and transferee company of juristic persons and corporate bodies. While considering the question of approving the scheme, such personal disputes between the directors of the transferee company and directors of the transferee company were completely irrelevant and were out of consideration of the equity shareholders who were not at all concerned with this time. I am adopting this submission. This is what my submission is. And then kindly look at paragraph 26.
To adapt,
Sorry, my lord.
to adapt this, any royalties required to be paid?
My lord, yes, my lord, I would imagine, my lord, but my lord, I can't, my lord, at least, my lord, Mr. Sorabji, my lord,
No, no, estate, we are now talking of estate.
estate.
But I think it would have been better for the bar if that policy was there.
Yes, my lord. Yes, my lord. But then, my lord, the difficulty would have been sometimes, my lord, we argue this side, sometimes we argue on that side. Then, my lord, there would be a difficulty.
There is perhaps, I don't know about the modern days, the present days, but earlier, about 25 years back, I think the bar at Visakhapatnam was one of the best bars for the juniors. There, they had a practice that in a particular room or a table, they would engage junior councils, fresh junior councils, to go and give attendance in particular cases of that court. So practice in the bar is that somebody will say the court number 1 who is going. He said, I am going. So he is given some
Right.
small amount, and then they are sent to the court for court attendance. They don't have a Hajira system.
Huh.
They have to give a court attendance.
Yes.
So the young junior gets a good fee
Income, my lord, too.
from the seniors, and then the seniors would go to the court only when the matters are called. So they take a good care of their new young entrants in the bar.
Well, now, my lord has seen, my lord, our my lord, Chief Justice of India, my lord, is now, my lord, has said and that you'll have to pay proper amounts to your juniors and all that, my lord, is now.
That's again debatable, but this practice in Visakhapatnam bar
It's, my lord, commendable,
is commendable.
commendable.
So a young junior doesn't have to be dependent only on one senior.
Correct.
So he gets the
From all the
people in the bar a particular amount. At that time, I would think it was 20 or 30 rupees. So they would get it, and the dedication is high there. So one would end up having 200-300 rupees for the day. And that was good enough.
which is, my lord, quite a substantial amount, my lord, at least, my lord, those days, my lord, would have been, my lord, quite substantial.
Let's see. So that's why when my brother is giving a suggestion, is go to the bar. They're thinking of that.
But the royalty should go to the bar, is that, my lord, a suggestion, my lord, that is.
Beyond that, we can't say anything.
Sorry, my lord.
Beyond that, we
No,
can't
no.
say anything.
My lord, paragraph 26, my lord, will find the issues, my lord, are there. In view of the aforesaid rival contention.
Just a moment. I was reading something in paragraph 25,
Yes, I'm sorry, my lord.
the last part. The contention was afterthought. What was it? Okay, that was a submission. Okay, yes.
Yes, sir. And, my lord, very important, my lord, since my lord was looking at, my lord, there 95% voting strength which approved the scheme and 5% which was opposing.
Yes, that's
Well-
right. Yes.
So very similar situation, my lord, there also, my lord, with regard to Mr. Mihir Mafatlal and my lord. Now, 26, my lord, will find. In view of the aforesaid rival contentions, the following points arise for our determination. Whether the respondent company was guilty of hiding that, my lord, then 2, whether the scheme is unfair and unreasonable to the minority shareholders represented by the appellant. Then 3, whether the proposed scheme of amalgamation was unfair, amounted to suppression of minority shareholders represented by the appellant and hence liable to be rejected. So, my lord, 2 and 3, my lord, then 5, whether the exchange ratio of 2 equity shares of ML for 5 equity shares of MFL was expressly unfair and unreasonable to the equity shareholders of ML. Consequently, scheme of amalgamation on the account was liable to be rejected. Then, my lord, the issues are dealt with, not from paragraph 28, my lord, the sections are set out. Then kindly come to paragraph 29. 28A, my lord, will kindly come to. 28A, my lord, at page 517. However, further question remains whether the court has jurisdiction like an appellate authority to minutely scrutinize the scheme and to arrive at
Before
an
that,
independent
Can you
conclusion.
come to page 516,
516.
516? Uh,
Yes,
The right-hand column,
yes, my lord.
last part, it starts from, it is of course true.
It is of course true that so far as the company code is concerned, as per the statutory provisions of 391, 393 of the Act, the question of viability of the scheme will have to be judged subject to the rider that a scheme sanctioned by majority will remain binding to a dissenting minority of creditors or members, as the case may be, even though they have not consented to such a scheme, and to that extent, absence of their consent will have no effect on the scheme. It can be postulated that even in case of such a scheme of compromise and arrangement put up for sanction of a company court, it will have to be seen whether the proposed scheme is lawful and just and fair to the whole class of creditors or members, including dissenting minority to whom it is offered for approval, and which has been approved by such class of persons with requisite majority vote. And on 28A, however, further question remains whether the court has jurisdiction like an appellate authority to minutely scrutinize the scheme and to arrive at an independent conclusion whether the scheme should be permitted to go through or not when the majority of the creditors or members or their respective classes have approved the scheme as required by 391 subsection 2. On this aspect, the nurture of compromiser arrangement between the company and the creditors and members has to be kept in view. It is the commercial wisdom, very important, my lord, it is the commercial wisdom of the parties to the scheme who have taken an informed decision about the usefulness and propriety of the scheme by supporting it by the requisite majority vote. That has to be kept in view by the court. The court certainly would not act as a court of appellate appeal and sit in judgment over the informed view of the concerned parties to the compromise, as the same would be in the realm of corporate and commercial wisdom of the concerned parties. The court is neither the expertise, court has, should be, has neither the expertise nor the jurisdiction to delve deep into the commercial wisdom exercised by the creditors and members of the company who have ratified the scheme by the requisite majority. Consequently, the company court's jurisdiction to that extent is peripheral and supervisory and not appellate. The court acts like an umpire. This is what I was saying. Umpire in a game of cricket who has to see that both the teams play their game according to the rules and do not overstep the limits. But subject to that, how best the game is to be played is left to the players and not to the umpire. The supervisory jurisdiction of company court can also be culled out from the provision section 392. 392 is set out. And then kindly come to paragraph at 518, right hand side, we'll see Mancom is quoted from Calcutta High Court.
Which page?
518, right hand
Yes,
column, at the
yes.
bottom, learned single judge, will have.
Hmm.
Learned single judge of the Calcutta High Court in the case of Mancom Investments, relying on a catena of English decisions of the English courts and Indian High Courts observed as under on the power and jurisdiction of the company court, which is called upon to sanction a scheme of merger and amalgamation of companies. It is a matter for the shareholders to consider commercially whether amalgamation or merger is beneficial or not. The court is really not concerned with commercial decision of the shareholders until and unless court feels that the proposed merger is manifestly unfair or is being proposed unfairly and to defraud these other shareholders. Whether the merged companies will ultimately benefited or will be able to economize in the matter of expense is a matter for the shareholders to consider. If 3 companies are amalgamated, certainly there will be some economies in the matter of maintaining accounts, filing returns, various other matters. However, the court is really not concerned with the exact details of the matter if the shareholders approve the scheme by the requisite majority. Then the court only looks into scheme as to find out what is manifestly unfair, not in defraud or to do injustice to the other shareholders. Then will kindly come to 38. Number 1.2. I'll just find out where the AIR page para 34, page 524. so far as this point is concerned, Shri Shanti Bhushan, learned senior counsel for the appellant submitted modern days of corporate bodies, even though public limited companies are mostly controlled by big, influential, economically powerful families which have inherited entrepreneurial skill and expertise from earlier generations which had controlled such enterprise in past. Present case also director of the respondent company, Arvind Mafatlal, eldest male member of the family, had descended from the common ancestor Mafatlal Gagalbhai, who had established empire and which has grown further with passage of years. When a powerful director who is the eldest male member of the family is helm of affairs, the minority of the interest of the appellant, who according to him was entitled to 50% shares in the family concerns as per the 1917 family settlement, was likely to be voted out and cornered by the influence of such a towering personality as Arvind Mann, meeting of equity shareholders. Well, this was the submission made. Therefore, unfairness of the scheme has to be judged from the point of view of its impact on the minority shareholder who has a common ancestor, Mafatlal Gagalbhai, and who sought to be cornered and deprived of his just share in the family companies by the machination of Sri Arvind Mafatlal. Court is therefore to see, then this submission is made, and then kindly come to at 5:25. At the top, third line, will find aforesaid decision. Has that, page 525, right hand column. The aforesaid decision is a pointer to the fact that what was required to be considered while sanctioning the scheme were bona fides of the majority, acting as a class and not of one single person. It is therefore not possible to agree with the contention of the learned senior counsel for the appellant that the majority had acted unfairly to the appellant and had not protected an interest when what was to be protected was the class interest of minority shareholders falling in the same class along with the majority. It is not the contention of the appellant that while voting by majority in favor of the scheme, majority had acted with an oblique motive to fructify any adverse commercial interests qua him and his group when it consisted of outsiders like financial institutions, or that there was any possibility of their surrendering the economic interest in the scheme at the dictate of the shareholder director Arvind Mafatlal and his group. It is also to be kept in view that the board of directors of respective companies, namely the transfer company as well as the transferee company, had approved the scheme of amalgamation before it was put to vote. Appellant was himself one of the directors of the transfer company who had no objection to the scheme, point of view transfer, so one of the consensual censor director. Then kindly come to one more paragraph. 38. That's valuation. Huh? Sorry, 13. I'm sorry, may I also show paragraph 37, point number 3, 37, at page 527. 527, paragraph 37, page 527, paragraph 37, the left hand, and dealing with point number 3. In a way, the answer to point number 2 necessarily results in negating this point also. Even that apart, we fail to appreciate how the scheme of amalgamation can be said to be unfair and amounting to suppression of minority shareholders represented by the appellant. Has to be kept in view that this proposed scheme of amalgamation, the transfer company was getting merged in the transferee company. Even if it is held that the appellant succeeded in his counterclaim in the suit pending in Bombay High Court, and if he is to get the shareholding of Arvind Mafatlal and his group transferred to him, so far as transferee company is concerned, transferee company, because of the amalgamation, will be having more diversified activity in if at all, according to the appellant, because of this future success. If any in the counterclaim, he is going to replace Arvind Mafatlal and his group in the management restaurant company. He would have larger field to operate and larger company to manage. We fail to appreciate as to how such a scheme, from any point of view, can amount to suppression of appellants' minority shareholders in the shareholding of the company. This interest is not going to be in any way adversely affected. If at all his shareholding is going to increase in the respondent company, if his counterclaim succeeds, if his counterclaim fails, he will have to get out lock, stock, and barrel from the respondent company. He'll have to wash his hands of the same. In either case, the scheme of amalgamation will have no adverse effect on the appellant's interest in the respondent company. On the other hand, scheme of amalgamation likely to have more beneficial effect on the appellant's shareholding in the respondent company if it succeeds in its counterclaim in the Bombay High Court. It has to be kept in view that question of bona fide of the majority shareholders or the alleged suppression by them of the minority shareholders or their attempt to suffocate the interest has to be judged from the point of view of the class as a whole. Question is whether majority equity shareholders, while acting on behalf of the class as a whole, had exhibited an adverse interest against the appellant's minority shareholders, also having similar interests as members of the same class, while approving the scheme or had acted with any oblique motive to whittle down such a class interest to the minority. As we have seen earlier, no such situation ever existed both at the time when the scheme of compromise and arrangement was cleared and proposed by the board of directors of both the transferee companies, and also at the stage when the scheme was put to vote before the meeting of equity shareholders, equity shareholders forming a common class, of which the appellant was also a member, though a minority member. Consequently, point number 3 will also have to be answered negative on the same lines, and for the same reason, the basis of which point number 2 is answered. Now, just pausing here for a moment. Kindly, also contemplate the situation here. B&A is gaining a garden.
It was closed.
Sorry, Malad.
It was closed for a long time.
Yes, normal it's functional. That's not the, but it is gaining an asset. So, Malad, the shareholder who Malad now has 3% or 10%, if what she says is correct, is 38%, she gets more asset. So similarly, Malad, here, that's why Malad, I showed paragraph 37. The logic was, Mihir Mafadlal said that I actually have 50% of this company by reason of the 1997 family settlement. This was also Malad, a scheme of Malad amalgamation. Here also Malad, it's a scheme of merger amalgamation. So court rationalized that yes, now Arvind has 95%. Mihir has only 5%. If Mihir, what Mihir is saying is correct, he will get 50%. Then he'll have a bigger company. Now, Malad, kindly put that same logic, Malad, in our case. And see, it's the same interest which we are both canvassing. So there is really no logical basis as to why, Malad, my learned friend's client, Malad, will oppose a merger. I understand, Malad, I am selling off the assets. It's a demerger. I can still, Malad, accept, Malad, a contention that yes, you're now giving it away. You're hiving off. And by the time I get the company, there will really be nothing. You're hiving off. That's the purpose. But here, you're gaining an asset. And even if, Malad, today, Malad, the finding of Malad, the learned judge, Malad, is, Malad, in our case, with regard to Malad, Rockland Realty, Malad, which owns Boragoet, Malad, Tea Company Limited, Malad, the appellant number 2, is also owned by the promoters, which is B&A Limited. Therefore, Malad, if she succeeds, she also, Malad, has, Malad, this asset, Malad, which is that of the company. Now, Malad, kindly look at, Malad, now on the question, Malad, what, Malad, the Honorable Supreme Court had to say, Malad, on the question of, Malad, valuation. 520. 38. Kindly come to, Malad, paragraph 8 or actually. I'm sorry, just want to kindly give me 1 minute. Issue 5. 38. 39 is, Malad, point number 5, Malad, on the question of, Malad, exchange ratio. Uh, 39, Malad, at page 529. it was submitted. Yes. Sorry, it was submitted that the exchange ratio of equity shareholders as far as the transferee company is concerned works very unfairly and unreasonably to them. As per the proposed scheme, 5 equity shares of transfer company are to be exchanged for 2 equity shares of transferee company. So far as this contention is concerned, it has to be kept in view that before formulating the proposed scheme of compromise and amalgamation, an expert opinion was obtained by the respondent company as well as the transfer company, namely MFL, on whose board of directors appellant himself was a member, Mrs. C.C. Chokshi and Company, reputed firm of chartered accountants. Having considered all the relevant aspects suggested, the aforesaid exchange ratio keeping in view the valuation of shares of respective companies. It must at once be stated that the valuation of shares is a technical and complex problem which can be appropriately left to the consideration of experts in the field of accountancy. Pennington, in his principle of company law, mentions 4 factors which have to be kept in mind in valuation of shares. Then one of those are stated. Then after that, so many imponderables enter the exercise. After the setting out, enter the exercise of valuation of shares. Mrs. C.C. Chokshi and Company, considering all the relevant aspects and obviously keeping in view the accounting principles underlying the valuation of shares, suggested the said ratio, which was found acceptable both by the board of directors of respondent company as well as the board of directors of transfer company. That the appellant himself as the director of transfer was given green signal scheme into the very ratio of exchange of shares. But Sri M.J. Thakur, appearing for the appellant, submitted that from the point of view of the transfer company, it was very profitable to have 2 shares of transferee company against 5 shares of transferee company. But the difficulty arises only from the point of view of the transferor company. It was very profitable to have 2 shares of transferee company against 5 shares of transferee company. Difficulty arises only from the point of view of transferee company shareholders, as according to Sri Thakur, the proper exchange ratio would be 1 share of transferee company to 6 shares of transferor company. It is difficult to appreciate this contention of the appellant. It has to be kept in view. The appellant never bothered to personally remain present. This is very important also. It is very important. It has to be kept in view that the appellant never bothered to personally remain present in the meeting of equity shareholders for pointing out the unfairness of this exchange ratio to his brother equity shareholders, who were likely to be affected by the very same ratio as the appellant. His interest, at least to that extent, was entirely common and parallel to that of other equity shareholders, but he had no time to remain personally present. He sent his proxy only to record his dissent vote, which was microscopic minority of 5% as compared to 95% majority vote. Not only that, even before this court, he did not submit any contrary expert opinion regarding the valuation of shares of transfer and transferee company for supporting his ipse dixit that the correct ratio would be 6:1 so far as transfer and transferee companies were concerned. Then this gets considered. Page 532. Paragraph 40. Page 531. Aforesaid report of the chartered accountant weighed heavily with the transfer company's board of which compromise amongst others. Appellant also board of transferee company also weighed with general body of equity shareholders, approved the scheme and the ratio with overwhelming majority. No grievance therefore can be made by the appellant at the stage of company petition proceedings for demonstrating the ratio to be ex facie unfair and unacceptable as the appellant would like to have it. And then the appeal is also dismissed because at last page 533 will file paragraph 43 appeal. Result is the appeal fails, dismissed in the facts. I'm submitting that this case is in all fours with what we have here. And the learned single judge, after having held that the scheme is economically justifiable,
Yes, please.
should not have reopened, and that's I'm sorry I'm repeating that, but should not have reopened the question of share exchange ratio because it has other repercussions. it is really going against the commercial wisdom of the shareholders of both companies. From the Mafatlal case, my lord, three my lord, submissions I want to make. One, my lord, the court really ignored the intra-family dispute with regard to the shares. That's my first submission, my lord, on Mafatlal judgment. Mir was claiming, my lord, 50% of my lord, the entire shareholding. Here also, my lord, my learned friend's client, my lord, is claiming, my lord, she says I'm 38%. Whether she is or she is not, that is, my lord, something which will be decided. Court held that, look, you can't be prejudiced because you are gaining another asset to the company. In Mafatlal also, my lord, they were merger. Here also, my lord, it's a question of merger. You are gaining an asset so far as the company is concerned. Secondly, my lord, I submit that, my lord, the court said that let's not get into the share exchange ratio. It's best left to experts. In our case, my lord, the court has really said, looking at, my lord, the shares and said, very well, this is 7,800, 786 rupees 10. So I'm multiplying it into 7,000. And the other share is 1,000. Therefore, I can see a difference. But I'm sorry, my lord, that is not really, my lord, how valuation is worked out. There are other considerations. How valuable is the company? Because it's not a factory, my lord. If it lies close, my lord, it will lose its worth. It's a tea estate. So, my lord, I submit, my lord, taking away, my lord, from Mafatlal, court should not really not have, my lord, if I may use the expression, gone into, my lord, the share exchange. Said very well, why should I interfere? Your dispute, I'm not going to get into the dispute. The dispute is before some other forum. If it is economically justified, then I'm sorry, the regional director also had no business. And that's, my lord, I relied on, my lord, Bengal tea. Regional director also had no business to really come and say that, oh, it's oppressive to minority shareholders. And, my lord, another thing, my lord, sorry, my lord, the third thing, my lord, or the fourth thing, my lord, from Mafatlal, it also comments on the fact that Mafatlal Mihir did not go to the meeting to express his objections with regard to the share exchange ratio.
Here, their ground is that they were never served a notice.
My lord,
That's
that's right. That's right. My lord, how else do I prove, my lord? That's why, my lord, I showed, my lord, the chairman's report. Wherever, my lord, and my lord knows in the company's, my lord, register, wherever the address is. And you are already in litigation. You are aware of all this is happening. And you say you are 28, but you will not bother. And also, my lord, very important. Now, my lord, the share, the claim might be more, but at that time, my lord, share was insignificant.
Have you elaborated as to how this round of raising the objection that it is going to be oppressive to the minority shareholders by your formulation? Is it possible for you to lay it before the court, or did you lay it before the court, before the learned civil judge, that as per the formula adopted, there's no question of loss or oppression to the minority shareholders?
My lord,
extending the objection raised.
My lord, how we formulated, my lord, of course, my lord, we showed, my lord, how, my lord, the scheme was approved, my lord, by the majority shareholders. We showed Bombay Stock Exchange. And, my lord, like I said, my lord, the incidence of the fact that, my lord, some shares are getting to, my lord, percentage of shares, my lord, in B&A Limited is going, my lord, to the shareholder of Buragua Tea, is an incidental, my lord, consequence of, my lord, this amalgamation. So that can't be oppressive.
And Buragua is owned by,
My lord, another company called Rockland, which is, my lord, in the same management group.
where perhaps she is not a shareholder.
She's not a shareholder. She's not a shareholder. So she objects, she said, no, no, my shares are getting diluted. I'm saying that is not the consequence really. You have to look at the larger picture. You have to look at the larger picture of this company, everyone approving. The shares today which you claim, that 27.8%, that share went and voted in favor. You can't have a higher right than what you inherit. Even if assuming you were to get this shares, even if you're assuming that you were to get this shares, you can't really now disown what is already there. I'm sorry, I think I've crossed my time. I'll take not more than 15 minutes, half an hour maximum. I have to show some judgments. And we've also got copies of the other company petition. I'll give a copy. The 245 petition. So sorry, sir.
Is it not a part of the paper books,
It is not a part of the paper books. I'm giving a copy their petition,
which was dismissed?
which was dismissed. Also, this is the second petition.
Second round.
I've not made a note. If kindly makes a note, otherwise it might. This is the section 245 class action, which is it also puts note, it ties up with item
September 21, 2020.
in September, page 12 of the list of dates, September 21, 2020. Just perhaps it may identify that. Filed on September 21, 2020 at page 12 of the list of dates.
September
21, 2020. Page 12 of the list of dates. Now, I think the most difficult part comes, try and have my lords back, with the matter.
we'll have to fix a date, another date.
Yes, Malad.
Both of you,
Is it possible,
both of you agree to a date?
sir, 28th or 29th August for this? It's possible, 28th or 29th of August, it's a Wednesday. 29th, is a Thursday.
Both of you discuss the date.
Yes.
28.
28th?
is not a hearing day.
28th is not a hearing day.
That's it.
is otherwise
But-
not a hearing day.
Whatever is convenient, 28th or 29th, I think it's a Wednesday or Thursday, but whatever is convenient, to the to my lords.
This bench will be specially constituted, so it will not matter whether it's a hearing or. This bench will be specially constituted for certain cases. I don't think that.
No, you know our limitations. We may be in the outlying bench, we don't know. So we will just give the date, but say that subject to availability of bench.
Very well. And kindly, if it can be marked, part hard, because we have taken up considerable time of my lords. Don't want to, we get wasted.
The submission of Mr. R. Banerjee, Learned Senior Counsel, assisted by Mr.
D.N. Sharma.
D.N. Sharma.
D.N. Sharma.
And A. Basu. And,
Council remains inconclusive. Mr. D. Mazumdar, Senior Counsel, assisted by Mr. S. Biswas, Counsel for the respondent. You're respondent number 2 here.
Yes.
You're
In my
respondent number
opinion.
2. And the appellant in the Company Appeal 3 of 2016 is present. Yes, CGC is also there.
Yes.
CGC, who was there here?
Central government, they are R1 in our appeal.
Okay,
They are R1 in our appeal. Union India.
that's fine. As agreed to by both sides, the matter is parted on 29/8/2024. Just before that, you write the list of dates. Provided by the learned senior counsel for the appellant is retained in record. For the appellant, is retained in record.
Completed.
Remains inconclusive.
Now, after going to the judgment, I find that possibly I also have to pay royalty. But not to the council arguing, but to the.
Which one?
Is the Mohatla. I'll also have to pay royalty because.
You'll also adopt.
No, I'll pay royalty not to the arguing council, but to the honorable judges.
Honorable judges, after they deliver judgment, becomes public
No,
property.
that you have to reserve it till we superannuate.
No, not to the judges of this honorable court, my lord. To the
Okay,
judges of the honorable Supreme Court.
okay.
28th.
I'll be relying that what I keep hearing, I'll be relying on that.
So that precedent, that may not apply, but
Bring the royalty to the
bar,
legal aid fund.
regulate fund.
Malad, date Malad is keeping on the 28th or 29th, Malad,
29th.
whatever is convenient. 28th is a Wednesday, 29th is a
29th
Thursday.
is a hearing day,
Hearing today.
29.
29th.
Very good. Grateful. Extremely grateful.
And this one's concerned, subject to availability of bench. And please take a mental note that if required, we can,
Adjust.
no, we can spill over to the next date, Friday, and complete the matter.
Malad, 30th, Malad, I may have some difficulty, Malad, then Malad, can it be
No, but
28th
still,
and 29th?
because 28th is a motion day.
Motion.
We have difficulties. So, no, perhaps you said 15, 20 minutes.
Yes, Malad, I will
So
not take,
then-
Malad. Grateful.
Item 7 for hearing.
Senior is in court number 17.
Okay, after some time.
Item 8 for hearing.
Presentation from the petitioner. So, G. Sharma, and State Council is present. For instance, this is the matter stands adjourned today, list after a week.
Item 9.
The matter was previously listed. Did you say when Mrs. G. Sharma, State Council is present? On 11/5/2023. This court has asked an order that in the event of subsequent non-appearance, adverse orders or orders shall follow. Despite the said order, the petitioner remains unrepresented. Full stop. Once again, for ends of justice, the matter stands adjourned today. In the event of subsequent non-appearance, adverse orders shall follow. Just after a week.
Item 10,
May I please, Lord? My lord, in this case, my lord, the petitioner filed the WS. I first pray that, my lord, that this annexer may be seen. Annexer P9, page 33, the WS filed by the petitioner, my lord.
Yes.
My lord, here by the by this WS, my lord, the petitioner has challenged the verification investigation made by the investigating officer, my lord. Entirely, may I read, my lord, WS?
Yes.
That there is no cause of action for filing case against the opposite party, and for the want of proper cause, case is not maintainable in law. That the report of the verification officer, that is that the opposite party entered after 25/3/1971 without any valid passport, and which is strongly denied by the opposite party, as because the verification officer has, without proper inquiry and investigation, submit his reports that the opposite party is a suspicious citizen of India. That the whole investigation and inquiry of the verification officer is based on false information and false allegation, which is against the principles of law of natural justice, that the opposite party being not inquired and investigated in this matter. That the opposite party born in the village Gopalpur, PS Kurandigi, district Uttar Dinajpur, West Bengal. Therefore, he is an Indian citizen by birth. That the opposite party, Sri Manik Karmakar, is an Indian citizen. It is because he is a legal voter and he is a holder of identity card from Election Commission of India. That the father of the opposite party, Sri Darpanarayan Karmakar, is an Indian citizen. It is because he is a legal voter and he is a holder of an identity card from Election Commission of India. That the opposite party was reading up to class 5 in the Madargasi class 10 government aided high school in the district of West Dinajpur of West Bengal. That the opposite party, Sri Manik Karmakar, have a landed property in West Bengal. That the opposite party is a holder of ration card.
Mr. Dey,
My lord.
you please look at your cross-examination. The name of the father is different. You are saying that your father is a legal voter,
My lord.
but in the cross-examination,
My lord,
there's some different name
it's
given.
spelling, my lord, Darpanarayan.
No. In the written statement, there is no introduction to
My
that.
lord, I am coming to that, my lord. I am coming to that. My lord, paragraph 10, my lord. For proper income source, before few years, the opposite party came to the village Nokhula Grant, POPS, Jagir Road district, Morigaon, Assam, and resided temporarily. That the authority did not verify the documents of the opposite party, as well as did not allow the opposite party to furnish the documents, but with ulterior motive
with view mechanically institute the case against the opposite party. Hence, this case is liable to be dismissed. The opposite party will be able to prefer the case by producing documentary evidence and also the adducing oral evidence to substantially his nationality, that he is an Indian citizen. That the authority filed the above noted case against the opposite party only to harass the opposite party, not only both physically and mentally, but also
Mr.
financially
Dey.
without providing.
Mr. Dey,
My lord.
under the new changed circumstances,
My lord.
is there any difficulty in applying?
No, my lord, there is no difficulty. But my lord, my humble submission is that, my lord, kindly see the verification report, my lord, there is nothing. And in the
No,
verification,
no, it says no. No means if you don't produce any documents, then also it will be said no. It's not your case that this particular documents were handed over to him. Because
My lord,
in many
refer-
cases, we have found that the documents produced are kept as along with the this verification reports. In this case, there are none.
none, nothing.
So therefore, it was not available.
My lord, kindly see the verification officer's report.
You've
Is
seen that.
the LCR, my lord.
You've seen that. You see this this verification
And-
report. I'll tell you why.
And the LCR itself, my lord, it is stated that he was born in West Bengal.
That's what you projected, and it is written
And
as per electoral roll. You also refer to our electoral list written. This local verification report.
some question of referring the matter to the tribunal to decide whether he is a, my lord, foreigners coming from Bangladesh, whether that
Sir,
question arises, my lord.
That's why we
On the
are-
basis of that LBO
No, that's
report,
what-
my lord.
That's what Mr. Devi are asking
That's
you.
my humble submission, my lord,
You see,
before his lordship,
this reference was made on 7/11/1997,
my lord,
correct?
my lord.
On 7/12/1997, now here you are producing the transfer certificate of a school which was issued on 30/12/2012. That means it is after the verification. And second, this is the date of birth is 1/5/1972, but this document has come into existence 30/12. No, it was 4/11/92. So, it is not like that. It's 30/11. 30/11. 30/11. It's fine, sir. I don't think anybody can do that. Look at this. It is at least 97. And this would be resistance to the incident. Yeah.
And as per the recent judgment, my lord, that is Rahim Ali's, my lord, Supreme Court
That is
judgment,
what we want to know,
my lord.
that during the investigation by the local verification officer of the police,
My lord.
the documents which you are relying on are all post 2012. So obviously you did not have any documents.
My lord, he is a resident of West Bengal.
Your allegation is that perfunctory, superficial investigation, and you were not given opportunity to
My
produce. Now, the documents which you have produced before the tribunal are all post 2012.
Or 2012, my lord, because my
It
lord,
means that you did not have these documents at that point in time.
my lord, documents, my lord, documents is the 1995 documents is the voter list, my lord. Not, yes, 1995 voter list, my lord, of his father. Darpanaran page, annexer P, page 14. Page 14. This is the voter list of his father, Karmakar Darpanarayan. The father's name.
But transfer certificate says Dakshan Lal Karmakar, different name.
Transfer certificate, my lord, his father's wife, voter ID also there, my lord, page
No,
and
that is-
16.
They. We are just trying to assess the documents you are having.
My lord.
The transfer certificate of the school has a different name of your father. You are
My lord,
showing the voters list.
Transfer
voters identity
certificate,
card, Voter identity card of 1995.
Darshalal Karmakar. My lord, the spelling mistake, my lord, is the Dorpalal, this is Darshalal. His father's name actually Dorpanarayan Karmakar. And in the transfer certificate, my lord, it is written Darshalal Karmakar. Some spelling mistake is there, my lord. But it does not, one document, my lord, it does not mean that he is a foreigner, my lord, he is a come from Bangladesh. Where the reference itself said he was born and brought up, my lord, born in West Bengal. And he categorically stated that he is from West Bengal. And he has the landed property at West Bengal. Voter list, ration card, etc. also from West Bengal. Question of coming from Bangladesh, my lord. This is not the foundation of this case is actually wrong, my lord. And the referral authority, without applying his mind, they referred the matter to the tribunal, my lord. That is, and the full bench in the full bench division, my lord, also stated in paragraph 98, my lord, that the referral authority should apply his mind on the verification report,
These documents were never produced.
my lord.
You see, the reason is you come to your land document which you are referring to.
My lord.
What is the date when certificate copy was issued?
Certified copies were later on collected, my lord. 1994. Manik Karmakar, my lord, page number 22. 4/7/1994. This issued
Page 22.
4/7/1994. It is issued by lord. And attested, it is headmaster is attested.
No, no.
That is another
What
issue.
is the date of issue?
4/7/1994.
4/7/94.
Yes, ma'am. Page 809. There was 809.
Certificate to
809. Where is it? This is what.
this is the-
Transfer.
Copy. 91. There's something wrong. Mr. Sharma and Ms. Dey, please look at this document. Put a green flag. Now, this document
Yes.
is Khatian number in the top,
91.
Khatian number 91.
Yes, Lord.
Now, page 22, which you are showing, is Khatian number 1231.
Yes.
1231.
Nineteen
Then
ninety.
in this original document, which is there in the flag, in that document, there's a date of issuance of certified copy. That is 12/7. The year I can't read. So if it is 12/7, it could not have been attested on 4/9, 4/7.
Yes, 30, 11, 12.
I don't know this, I can't read that next part. You see the document. Date of issuance of certified copy is different. 12 or 13/7.
It was attested.
Therefore, how can a Khatian change? Page 1, it is 91, and second page, it is 1231.
Second page. Second page. Your second page.
P3.
Now, this,
The hotel number to go this. It hotel number 90. 60. My lord, one is one Khotian, 1991 Khotian is the name of his father, Darpanarayan. And the second Khotian is in the name of Manik Karmakar, 61. LJ 61, Khotian number 1231. Manik Karmakar.
Malik is your name.
One is 1991 Khotian, my lord, in the name of Dorpolal.
Dorpalal Das, Lordship. And son of Khargamohan Das.
What is your father's name?
My lord, Darpanarayan Karmakar.
Narayan.
Darpanarayan Karmakar, actual name, my lord.
Then how are you connected to Dorpalal Das?
My lord,
Hmm? Number change हो गया। Because नहीं है।
तो दिनाजपुर में वेस्ट डिस्ट्रिक्ट हो रहा कोई
Thana, North.
is the district West Dinajpur or North
Pargana.
Dinajpur?
my lord, he is a resident, permanent resident of my lord, West, North Dinajpur, West Bengal. And the school is, my lord, situated in, my lord, school certificate says West Dinajpur. 20. School is situated West Dinajpur, but he is a resident of Uttar Dinajpur. Uttar Dinajpur.
What is this page 24?
Page 20. This is the revenue, my lord, revenue receipt, Khazana, Dakhila, Alam.
Who is this Bimal Karmakar? Biman. What is the name here?
Darpanarayan,
Bimal Karmakar. Father's name is Darpanath
Riyan Kormakar.
Das.
Riyan Kormakar is brother.
I think we prepared, we are not satisfied with the documents.
Manik Kormakar. Name of the holder.
And what is the date of this land receipt, the revenue receipt? What is the date of issuance?
Date.
Because of post 25 71 document will have to be viewed differently. Should they be prepared with your instructions? Yes, Mr. Sharma, I can't read the date in that.
Yes, Lordship,
land
I
document.
could not find Lordship.
No, what is the year of Khatian?
Page-
Khatian is year wise. What is the year of Khatian?
Year of Khatian. You made Khatian number. So these are long.
Khatian number 107. And Lordship date, I could not find Lordship. My lord, page 24 in the revenue received here, Khatian number is 107, but date I could not find Lordship.
Yeah. English is a place, right?
Next page. Actually, The dates. Here mentioned, no?
This page 18, Mr. Day,
My lord,
there's a court fee stamp, page 18.
page 18.
Below the court fee stamp is a date. What is the date? 12/7.
Copy.
Page 18. The court fee stamp. Below that stamp is a date.
Yes. 12/7/79.
This is not 79.
Yes, Lordship.
No, 7 is differently written. Here it is. It's not 7. 12/7, 7 is very clear.
79.
Lordship in record, Lordship. I think Lordship it is 79.
79, my lord, it seems to be 79, my lord. 12/7/1979.
No. 12/7 they will write in English.
79. And my lord, attested in the above, attested date is, my lord, in the above
11,
3 to
2012.
1964.
No, that is different. That is the entry date where I don't know.
No, my lord, this is, I am also, my lord, it's very difficult, my lord, to understand the.
No, take instruction and addresses. We'll take it up after a week. All of these are post 71 document. If you can show this to be a 64 document.
Chittaranjan Park. Road. Certificate to be required.
You get instructions, you're not satisfied. All sides are represented. And the prayer made by Mr. P.C. and also for the petitioner, the matter stands adjourned to enable him to obtain instructions. List after a week.
My lord, I may be allowed to give some additional documents by an affidavit. My lord.
No, we are not giving a leave. If you want to file it, we'll see it as it comes. But we are not granting a leave because this would be an invitation from the court to add that documents at the stage. Produce it, we'll see, we'll examine. If it is worth accepting, we'll accept it.
Subsequently, my lord, I have collected some documents which are not,
No, we are not giving a leave.
my lord.
You may file it, then we'll examine.
My lord. Must.
Time being item 7.
May please, your lord.
My lord, here the case was decided on contest. The impugned judgment lordship will find at page 33.
This
My
is no
lord,
document at all. Your written statement is at page 7.
Yes, my lord. My lord, so far the impugned judgment, my lord, the learned tribunal has hold a view that I failed to link with my parent, father.
There is no document.
My lord,
This way we are showing your written statement, page 7 and 8.
yes, my lord. Yes, my lord, written statement. May I read out, my lord?
Well, you read that. That's why we are pointing it out.
My lord. My lord, of the statement, my lord, of the written statement, although very short, but relevant portion, substantial portion is there. He was born in village Kaibari, PS Ovapuri district, Bongaigaon, that is in paragraph 2. And now he is presently residing in Nolbari town, Sonpur, ward number 9. And my lord, paragraph 4, the father of the OP is late Sirish Chandra Burman, alias Sirish Chandra, and his name has been enlisted in the voter list of 1965 for Bhojpuri. 42 LSC of Kaibari under so-and-so. Mother's name is Sumitra Bala Saha, whose name also appeared recorded in the same LSC under serial number so-and-so. That in the year 1975, OPs himself shifted his residence to Nolbari town, PS district Nolbari, for better livelihood as working carpenter. The OP's voter of 59 number Nolbari LSC, and his name has enlisted in the voter list of 1985 under serial number so-and-so, house number so-and-so. Well, these are the materials he has disclosed. He has also denied the allegation. My lord, annexer.
When were you born?
My lord.
When were
He
you born?
He born in, my lord, in Kahibari, Abhaipuri, PS Abhaipuri district, Bongaigaon. That is in paragraph 2.
Which year?
The year he has not mentioned. But his age is disclosed in the evidence in SIF, as well as, my lord, additional evidence and cross-examination. So on the date of evidence, my lord, he was 58 years. That was of 2017. 2017, my lord, it will be around 1959. He was born, my lord.
Born in which year?
My lord.
Which year?
My lord, in 1958, my lord, 1958, 59. 50 years. He was 59, my lord. 2017, he declared to be aged about 58 years. So he born, my lord, in the year
I think something is
1959.
wrong. Your name is what?
My-
Adhir Chand Burman. You're Adhir Chand Burman.
My lord.
Come to page 21. The date of purchase of the land is 10/1/68. If you're born in 68, you could not have purchased land in 68.
68, yes, my lord. My lord, he along with his elder brother purchased the
That's
land.
okay, but in 68 you were born.
My lord, whether it is, if he was minor at that time.
Then somebody would purchase it on his behalf.
My lord, he purchased, not he is alone, but with his elder brother. Perhaps he was minor, elder brother has purchased, but his name is also included. And this Transfer of Property Act does not, my lord, put a bar that minor cannot purchase a land. My land cannot be purchased
No,
in
you're
the
not
name of
disclosing, you see, you're not disclosing your date of birth. Therefore, we don't know what is your date
My
of
lord.
birth actually.
my lord.
You were born in 10/1/68 or after that or before that, we don't know.
My lord.
But the statement you have made that we were born in 68, 69.
My lord, I
No, it's okay.
calculated,
I'm
he
not-
declared his age, my lord.
Mr. Sikdar, I'm not finding fault with you. The question is that when you are making a statement, I am going through the records, it must match.
My lord.
If it doesn't match, then therefore the questions. Because the document must exist, if you can show that this is you, then it is before 71 document and would be admissible.
My lord.
There is any other document to show?
My lord, voter list of 1966, my lord, 65, my lord, that is,
It shows.
lordship will find at page 16, at page 15, translated copy. Father's name Shirish Chandra. Then mother name Sumitra Bala. Well, one document, my lord, given by the police, my lord, after verification. Yes.
Original sale deed,
My lord,
you have the original sale deed, this is a certificate copy produced, do you have the original
my
sale
lord,
deed?
it was exhibited, I think it is
It is a certificate copy. which was
proved
exhibited.
original, my lord.
It was
certificate
certificate copy. Whether you have the original one,
Well, at this, my lord, we are appearing as an amicus curiae, my lord, so.
oh, acha, okay, I'm sorry. I'm sorry, yeah. Okay.
Linkage was highlighted. I mean, at least it cannot be a devoted price. Yes.
You have any land document?
My lord. Yes, my lord, land purchasing deed, my lord, annexer H. Vernacular at piece 23.
Perhaps that land is not there because you say that the land was purchased in Abhayapuri, but now you have shifted your residence to Nalbari.
Nalbari.
So
yes.
therefore, this land is either not existing or it is, that's why you don't have the original sale deed.
My lord, land is purchased with his elder brother. And my lord, the family is originally from Obaipuri. That was purchased in Obaipuri.
No, if there's a brother who has a land, he would have come and deposed in your favor. In favor of the proceeding. We are trying to connect you with this documents of your parents.
My lord, yes, for the purpose, my lord, for linkage, my lord, that could be, but in absence of that evidence of my brother or family members, whether the evidence produced before this
No,
one
no.
can be,
You see, we just wanted to identify you with the name and your father's name.
my lord.
That is the only purpose of asking questions.
My lord, kindly have a look at my lord annexer at page 9.
Because in your written statement, you don't introduce that land.
My lord.
In the evidence also, you don't say specifically about this.
My lord, annexer 9 may kindly be looked into, my lord. My lord, his status has been
just now.
verified by the border police.
Just now. How does this document has come in, this sale deed of?
My lord,
Sale deed of 68, where is that?
my lord, the police report.
No, the 68 land documents is where?
Yes, my lord.
That is,
It is also in the record, I think, my lord. I have noticed it available in the record also.
no, there is something else which is in record, not this.
Yes, my lord, there is another sale deed,
There is on Nalbari.
Nalbari. He purchased
Of-
land
of
also in Nalbari.
86.
But
Of 86. You have the evidence on affidavit of the proceeding.
my lord. Yes, my lord.
Exhibit
Evidence
1
in-
is a photocopy of voters list of 66.
Yes, my lord.
2 is photocopy of registered sale deed. This sale deed is 1986. This
My
is
lord.
not of 68.
My lord.
This is 86, para 6.
Yes, he purchased land in Nalbari.
No,
That
no,
is
that's-
exhibited
We are
exhibit
trying to
2.
connect you with the 68 documents, pre-existing, pre-71 document. 68 is the only document, but uh, this exhibit 3 is the voters list, ration card, trade license. Exhibit 8. And then there's And then there is a additional affidavit,
Yes,
certified copy of voter list
93.
93 and 97. So the 68 document itself is not there in the evidence. Now let us examine your police report, exhibit 8.
But we are relying on the voter list of 1966 of father.
But that you know, Mrs. Sikdar,
My lord.
voters list itself is not a proof of.
My lord. Why not, my lord? The voter list, my parents' name is there. I claim that my father in the voter list of 66. So I claim they have not denied it, my lord. Though materials, my lord, against me, my lord. They have to lead a rebuttal evidence. That is also in the my lord, Sarvanda Sunal 1 judgment paragraph 26, my lord. They are to verify and to lead rebuttal evidence. That point is never be questioned, my lord. And full bench also. They are to lead rebuttal evidence. Where is the rebuttal evidence? And how the case is coming up, my lord. Kindly see the inquiry report. It appeared that the inquiry, there was no inquiry. Statement recorded without signature. That is against the full bench judgment, my lord. Paragraph 97 clearly said that they are to take signature after recording statement. What has prevented them to take signature in recording the statement? So they have randomly picked up, my lord. That is gross violation of the fundamental rights of a person.
Let's see. Series building. Sending the government series building. Series building. You have your father's or mother's voter list?
My lord, my lord, 66 voter list, my lord.
Where is that? Which page?
My lord, page 16, my lord.
It is
15 is the translated copy.
exhibit
16
number,
16 is page 15, my lord.
no, exhibit number.
It is exhibit 1. That has been also discussed by the learned tribunal. In para 2 of the judgment,
Why was it rejected?
my lord,
Why was that rejected?
it is accepted, but the learned tribunal hold a negative because of linkage for want of linkage. Ah. The police report has not been properly considered, my lord. Police report has established the linkage. And the DW2,
This is that voters list of 66, page number.
my lord, page 15 of the writ petition. Vernacular at page 16,
Shirish Chandra.
my lord.
Invitation. It. What was the tree that used to that cease to be there?
May I put the record for the time being?
Hi, yes.
But before
First of all, my lord, my submission is that the WS is totally inadequate in this case, my lord. In fact, my lord, even though the WS is not the nomenclature in the my lord act order, but though it is stated as to be my lord representation, but even then, my lord, representation must have disclosed all the facts which he has to plead. Because
No, there's one point.
Yes.
He's producing a voter ID card of 66 of
Of
his father.
father.
And thereafter, there are documents of post 71, where his father's name is there along with him.
My lord, that's why, my lord. My lord, probably tribunal has also not, my lord, not doubted anything about documents of projected parents, but only thing is that whether the petitioner could prove that he is the son of the projected parent of whose name was there in 1965. That must only. That must
Because
be.
if he's holding a land in his own name,
Yes.
he would not, at that point of time in say 86, when he purchased, that time there was no reference. He would not give a name of different person as his father. So once the land holding documents are there,
But that is post 85, post 71 documents.
no, that is okay.
Yes.
But
My
the
lord,
fact is that somebody purchasing land would not
Yes,
give
my lord.
a wrong name of his
my lord,
father.
could post because my lord, this is not a my lord, these are not the proceeding, my lord, which are initiated only, my lord, in recent times. These proceedings are going on since 1964. The my lord, order, as soon as the order 1964 is coming to force, the foreigner tribunals were there, my lord. It is not that, my lord, probably in this case, probably he was the person concerned. He was referred later on, but these proceedings are there. My lord, we have to remember that the proceedings are there. This problem is there prior to my lord 64. And this, that's why with 64 or
This person.
yes, my lord, yes. But this person, my lord, that's why.
Yes. Is it? It is. Just 17.
From my lord, written statement onwards, my lord, if we see, my lord, in written statement, he has not introduced any documents, anything about, my lord, any land possessed by him. My lord, either of his parents or by himself, my lord. The lordship will find it a written statement. He has stated in written statement, my lord. Well, first of all, he has to plead at least what is his year of birth, my lord, because para 26 has clearly said he has to prove, my lord, some things. One is year of birth, one is place of birth, one is parents' citizenship, and in some cases, citizenship of grandparents.
No, you see, the case being made out is that in the writ petition,
Yes,
the petitioner says that he is 58 years of age.
yes,
This is an affidavit sworn in 2017.
yes.
This makes him
59. So,
1959.
yes,
Then he becomes 21 in the year 1980,
yes,
and he's producing a voters list of 1985, saying that his name is there. His
27.
father's name shown as
Her name is
Sirish.
Sirish.
So therefore, if he's become a eligible voter in 1980 and has his name in 85, you can't say it is too
Yes.
too delayed.
My lord, I'm coming one by one, my lord.
Ah.
First, the WS, my lord, what my submission, sir, and the WS, he has not disclosed anything about, my lord, lands which he is relying. Because these sort of, my lord, prima facie facts which he had to deny, and he had to disclose in his WS. First of all, he has not my lord, disclosed what was his year of birth. He has not disclosed anything, my lord, whether he has any siblings or not. And he has not disclosed the details family tree of the petition, my lord, of the entire family. So we cannot say whether this person who is a resident of, my lord, Nalbari district and my lord, as Adhir Chandra Burman is the actually son of that, my lord, Sirish Chandra Burman, who was there in Abhoyapuri in 1965 and 66. To establish that, he has to bring evidence, my lord. His only statement is that OP is a citizen of India by birth, permanent resident of Nalbari town, Sonapur, ward number Srencho. OP was born in village Kahibari, Abhoyapuri district, Bangladesh. There is no cause of action arose. Then he has given only one details, my lord, that father of the OP late Sirish Chandra Burman, alias Sirish Chandra, and his name has been enlisted in the voter list of 1965 Abhoyapuri alias so-and-so. And mother's name is Sumitra Bala Saha, whose name also recorded in the LSC 65. House number so-and-so. In the year 1975, OP himself shifted his residence to Nalbari town, PS, district so-and-so, for better livelihood and working. The OP is a voter of 59 Nalbari so-and-so. He is a voter in Nalbari since 1985. So henceforth, he is illegal. He is not an illegal migrant. That is the only WS. Now he has filed in his evidence. Evidence he has given that father's name. Evidence he has stated the photocopy of the voter list of 1966 proved in original. So Sirish Burman's name was there in 1966. In fact, we are not saying, we are doubting on him, on Sirish Burman. One Sirish Burman may have been there in Abhoyapuri in 1966. That is admitted, there is no issue on that. Then, in 1975, I have shifted residence. That is as per whatever he stated in the WS, my lord. He has given evidence to the effect that I have shifted my residence from Nalbari to Nalbari town. Now, in the year 1986, my lord, he said 2017, 1986, I pursued a plot of land measuring so this is the evidence which is not pleaded in the, my lord, WS. That was not pleaded in the WS. So he has gone beyond the pleadings of the WS, my lord. Then my name is enlisted in the voter list of 1985. That was pleaded. This part is pleaded, my lord, 85, but this main, which is the main crux of the matter, my lord, issue, which is the main document, it was not pleaded. It was not pleaded in the WS, that it is 86 document. my lord. The photocopy of voter list, which is proved in original. I have obtained a family ration card. Ration card is, my lord, not a proof of citizenship, it is settled position of law. The trade license, which is proved in original. Then exhibit 6 is a premium receipt of LIC Nalbari. These are of present, my lord. All these are of post 71 documents. And these are in the, my lord, in the Nalbari district. Now, only to claim that, my lord, I shifted in 1975 and I born in that village and I shifted in 1975. What is the evidence to the defect, my lord? What is the evidence that the person who was born in Abhayapur in suppose in 1959-58, he shifted in 1975, accept this claim, man. Somebody may come, my lord, what our apprehension is that somebody may come and claim that I am the son of so-and-so. That will not do, my lord. He has to prove by some documents or some link that yes, I was born in that place and I shifted into that place and I am the son of so-and-so. Now, thereafter, my lord, he has produced the 1985, my lord, this 86, these documents in evidence. This is
Just a moment.
yes, madam.
My lord,
This Kahibari is shown in this 66.
my lord,
There's no statement in the in the written statement is only said that Kahibari village para 4. Srichandra in the voter list of Srichandra village Kahibari. Question of shifting.
my lord. My lord, Dobles, it is mentioned, my lord, is born in Kahibari. My lord, in para 4, 65 voter list of Kahibari, my lord. It's mentioned in the Dobles. Father's name and mother's name, house number, serial number, everything is mentioned. My friend is emphasizing on the WS, my lord, but the Foreigners Tribunal Order 1964, there is nothing mentioned that prescription that WS is to file, only evidence. In para 26 of the Sarvanda Sunal 1 case also, only evidence. There is no whisper about the WS.
Representation is there.
No, but the act, the Foreigners Act and the orders, it refers to a written statement.
My lord, the Foreigners
Repres-
Tribunal Order 1964, there is nothing, my lord. There is nothing, my lord. Kindly have a look at, my lord. The Foreigners Tribunal Order 1964 is only evidence.
File representation, my lord, then evidence.
That is not WS, that is the,
Nomenclature
The-
may be different, but it is
and-
representation, my lord, my,
Where is-
only representation,
which
Three
provision?
only representation. That is not the WS.
Which provision?
My lord, the Foreigners Tribunal Order 1964,
three.
Order 3. Here only to make a representation and evidence. That means, my lord, the strict role of provisions of the
89.
CPC and the evidence is not applicable here. And there is a judgment of this honorable court. Strict role of evidence is not applicable.
1964 rule, my lord, may I read, my lord? May I read? The tribunal shall serve on the foreigner, on the person to whom the question relates, a copy of the main ground on which he is alleged to be foreigner, and give him reasonable opportunity of making a representation. That is the first sentence, my lord, making a representation and producing evidence in support of his case. And after considering such evidence as may be produced, and after hearing such person as may desire to hear, the tribunal shall submit its opinion to the officer or authority specified on this behalf, the order of reference. So first of all, my lord, there is reference. There must be a representation, and it should be representation, then, my lord, the evidence. So in numbers of judgments of this honorable court, it is settled, my lord, that the representation may be read at risk, whatever in my lord nomenclature it may be, it must contain it, like as we are filing in WS, my lord, WS, so it may be taken as representation. We are not saying it may be, should be filed as WS, but it must.
It. Supreme Court can say, but-
There's a judgment of this way.
Numbers of judgments where it is said my lord, the written statement must contain everything. Written statement.
Can you cite one?
My lord, this is, your lordship will find this is 2017. 2017 4 GLT 346. In fact, they, my lord, they file as a my lord, written statement, because in the trial court, they file it as a my lord, written statement, because it is. They
What's
themselves.
the date of judgment? This judgment is, please give the.
My lord, 2017 4 GLT 346.
17.
17 4 GLT 346.
Seventeen four zero two. Look, I know something.
Para 25, 26, 27, my lord.
Okay. Mr. Siddhar, we are taking up next week.
Well,
Because. There are 2 or 3 reasons. No? Because my brother is a single bench.
Well.
Single bench. The hearing in the matter remains inconclusive. All the parties are, all parties are represented. List on it. Make it Tuesday. Sixth.
My lord.
Giving it on a hearing day.
My lord,